Okay, I want to ask everyone to put their cell phones on silent. And welcome to the quarterly board meeting of the Osteopathic Medical Board of California. This meeting is being held on Thursday, November 14th, 2024, and it is 9 a.m. This meeting is occurring at the Department of Consumer Affairs, HQ3 buildings, their hearing room located at 2005 Evergreen Street, Sacramento, California, 95815. Today's meeting will be run according to the Open Meeting Act as required by law. The meeting will be conducted using the following guidelines. The board welcomes public comments on any item on the agenda, and it is the board's intent to ask for public comments prior to the board taking action on any agenda item. During each agenda item, the host moderating this WebEx event will activate the Q&A feature of WebEx and will ask anyone wishing to make a public comment to indicate so by replying yes. The host will then call on individuals who indicate they wish to make public comments by name that they've joined by on WebEx. When called, comments by the name that they joined the WebEx event is, the host will unmute the microphone and the individual, he or she, will have 3 minutes to make his or her comment. The host will audibly announce at the 15-second mark to conclude public comment. After the 3 minutes have elapsed, the individual will be placed back on mute. Only one public comment per agenda item is allowed per attendee. All participants will mute their microphone or phone during each presentation of the agenda topic. At the conclusion of the discussion from the board members, I will ask for public comment. At the conclusion of the discussion period, I will call for vote if necessary or move to the next agenda item. All in attendance should keep their comments specific to the agenda item being discussed. There is an opportunity for public comment for items that are not on the agenda, and it will be provided. Please be advised that during this comment period, the board cannot engage in discussions or take action on any matter that is raised except to decide whether to place the matter on the agenda for a future meeting. So now we're going to establish a quorum, and I would like to call the meeting to order and establish a quorum and ask that board members unmute their microphones. Machiko, will you please call the roll?
Good morning. Laura. Cora Damian.
Here.
John Cummins.
Here.
Dr. Lockman.
Here.
Andrew Marino. Dr. Patel.
Present.
Denise Pines.
Here.
Dr. Swain.
Here.
A quorum has been established.
Great. Moving to agenda item number 2, reading of the board's mission statement by our Executive Director, Erica Calderon.
Good morning, members. The mission of the Osteopathic Medical Board of California is to protect the public by requiring competency, accountability, and the integrity in the safe practice of medicine by the osteopathic physicians and surgeons.
Okay, agenda item number 3, review and possible approval of the August 2024 board meeting minutes. Associate Governmental Program Analyst, Beth Dutchler.
Good morning.
Good morning.
Can you hear me? Push button. Good morning. Can you hear me?
Yeah.
Yes.
Yeah, you can.
Is the mic working or no?
It's
Okay.
working. Okay.
Okay. Good morning. I'm here to present to you the August 2024 board meeting minutes for review and possible approval. I'm going through them page by page to see if there's any corrections or edits that need to be made. If there are no questions, I will start with page 1. Do we have any edits to page 1? Page 2? Page 3?
Excuse me,
Yes.
I think it's page 2, consumer watchdogs, would probably be consumer watchdog. It's in agenda item 3.
Uh-huh.
Is it just adding a letter S?
Yeah, it looks like there's a reference to two representatives who made comments to agenda item 3 as being from Consumer Watchdogs. I think it should be Consumer Watchdog.
Okay, make that edit. Page 3,
I have a comment on agenda item 5.
okay.
Agenda item 5 says, Madam President Pines introduced 3 new board members, Mr. John Cummins, Dr. Matthew Swain, and Dr. Brett Lockman. All new board members were sworn in. Actually, I wasn't present at that meeting, so all new board members present were sworn in.
Okay.
Would be more accurate.
Page number 4. Page number 5. Page number 6. Page number 7. Page number 8. Page number 9. And page number 10. Right, I'll turn it back over to you, Madam President.
Thank you. So can I get a motion to adopt the minutes from the August 2024 meeting?
Yep, I'll make a motion to approve the minutes.
Can I get a second? Oh, are there any comments from the public in the room? Any comments from the public online?
This is the moderator, and at this time, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. All right, it appears at this time there is no request for public comment on this item.
Okay, thank you. Next agenda item is item number 4.
Corey Damon,
Aye.
John Cummins,
Abstain.
Brett Lockman, Dr. Lockman.
Aye.
Andrew Marino's not here. Dr. Patel,
Aye.
Denise Pines,
Yes.
Dr. Swain,
Yes.
motion carries.
Next agenda item, number 4, public comment on items not on the agenda. During the meeting today, public comment is welcome on any agenda item as the item is taken up by the board. Please be aware that public comment during this agenda item should provide information to the board and is not a discussion between the board members and the public. The only action board members can take is to listen to comments and decide whether they want a future agenda item on the topic. No other action can be taken on the agenda item at this meeting. This may seem at times like the board members are not being responsive, but following these guidelines is critical to ensure the rules of the Open Meeting Act are followed to avoid compromising the speaker's goals or the board's mission. In order to allow the board sufficient time to conduct its scheduled business, the board will limit the time given to each person to 3 minutes. It is not necessary to repeat statements or views of a previous speaker. It is sufficient to just state that you agree. As a reminder, please do not disclose details of an active enforcement case or licensing matter. Such discussions are considered ex parte communications as they could provide information to members that is outside of the record in violation of the Administrative Procedure Act. Therefore, such discussions could create a conflict and lead the board to a decision being made and being challenged in Superior Court. The board can receive comments regarding the board's processes in general, but it cannot receive comments on specific case circumstances where the decision is still pending. In addition, the board would like the public to address the board as a whole and not individual members. The board appreciates your cooperation and assistance in meeting its legal mandate. If you want to comment on an agenda item, please wait until we get to that agenda item. Comments at this time are only for items not on the agenda. Please limit again your comments to 3 minutes at this time. Are there any public comments from members of the public who are in the room? Are there any comments from the moderator from public online?
This is the moderator. If members of the public on WebEx would like to make a comment for items not on the agenda, you can click the raise hand icon, or if you're an audio only participant, press *3 on your device. You may also use the question and answer feature down at the bottom right-hand corner of your WebEx screen. All right, and at this time, it appears there are no comments on WebEx.
Thank you. Moving to agenda item number 5, President's Report. The Osteopathic Medical Board of California spent much of the first quarter of 2024 fiscal year working hard to meet our objectives for enhancing consumer protection. The Osteopathic Medical Board of California has been dedicated to advancing consumer protection goals during the first quarter. Regular discussions with Executive Director Erica Calderon have been instrumental in shaping meeting agendas and progressing board projects. In line with our commitment to transparency, we are preparing for our inaugural open notice meeting with patient advocates in 2025. This initiative aims to listen to the public as well as for the board to share its intricate complaint process, its role, and enforcement efforts. As a board member of the Federation of State Medical Boards, I like to keep our state informed of what's happening nationally that could or will impact California. We have an ethics and professional work group that recently tackled the issue of cheating on the USMLE test out of Nepal and examined the influence of technology like AI and this impact on patient safety. We are looking at reentry guidelines and what the length of time before a reentry program is needed and a clear definition of clinical activity. Two other big issues in the corporate practice of medicine in which the state of California has one of the most prohibitive policies. And we've been looking at this across all sectors of the country. And using California as an example of good practice. And then finally, we worked on guidelines for states that are putting forth legislation to let foreign doctors practice without going through the typical process that we've had in place in this country for beginning of time, which is doing 3-year residency and taking exams. A law has already passed to allow foreign physicians to come into the country from Tennessee and Kentucky. The Medical Board of California does have a program with Mexico. It was a program that took 10 years of rigorous review and process and is working well. And we are using this on a national level as a guideline to the other states that are considering passing laws such as this. Are there any questions or comments from members about the President's report? Board members? Any comments from members of the public in the room? Any comments from the public online?
This is the moderator. For our individuals on WebEx, you may request public comment by raising your hand or pressing *3 on your device if you're an audio-only participant. You may also use the question and answer feature down at the bottom right-hand corner of your WebEx screen. All right, and it appears there are no requests on WebEx.
Okay. Let's move to agenda item number 6, board member communications with interested parties. Does anyone have anything to discuss? I will disclose one thing. I have a film that I recently worked on that the Federation of State Medical Boards accredited as a continuing medical education course. So I want to disclose that. Does anyone else have? a disclosure.
Yeah, just more of a disclosure slash comment. I attended the annual meeting for the American Society of Osteopathic Medical Regulators. We had a pretty good presentation by Dr. Gimple of NBOME. Just an update, the clinical skills exam that our osteopathic medical students take has been suspended indefinitely. And there's a pilot program to work with schools to create an accessible clinical skills program. And just a comment or a suggestion, it may be worthwhile to invite Dr. Gimple in the future to provide an update and see if we would be interested in pursuing, this pilot or encouraging our osteopathic medical schools in the state of California to adopt this pilot exam.
I also forgot to disclose something that just happened yesterday. I hosted a Senate briefing at the Hill in Washington, D.C. with Senator Patty Murray on the topic of menopause. Okay. Are there any comments from people in the room? Any comments from the public online?
This is the moderator. For members of the public who are on WebEx, you can click the Q&A icon down at the bottom right-hand corner of your WebEx screen or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. All right, and it appears there are no requests on WebEx.
Okay, moving to agenda item 7, Intergovernmental Relations Report and Administrative Services Update. And joining us for the DCA update is Ryan Thatcher, Legislative Project Manager, Division of Legislative Affairs from DCA.
Hello, my name is Ryan Thatcher. My normal job is with the Department of Legislative Affairs, but today I'm filling in for the Board and Bureau of Relations. So thank you for the opportunity to join you today. So DCA's Diversity, Equity, and Inclusion Steering Committee met last month, and we are excited to announce its newly elected leadership. Reggie Varghese, and with the Medical Board of California's Medical Director, will serve as chair, and Marlon McManus, the Board of Behavioral Sciences Assistant Executive Officer, will serve as vice chair. With Reggie and Marlon's years of experience and sincere commitment, we greatly look forward to accomplishing many DEI initiatives under their leadership. I am also excited to share that DCA is updating its current Unveiling Unconscious Bias training to specifically focus on board members, your critical roles, and how unconscious bias can affect your decision-making authority. The training will be self-paced and available in DCA's online learning management system, LMS. We anticipate launching this new training in early 2025, and board members will be required to take it annually. As a reminder, DCA offers over 20 online DEI training courses in its learning management system. While these courses are not mandatory, board members and board leaders are strongly encouraged to take these trainings, as you are instrumental in leading department-wide changes. Next topic is Military Licensing Resources Webinar. So to support and maximize outreach to our military community, DCA is hosting a second live webinar on November 21st, 2024 to share information about military licensing resources. During the webinar, attendees will learn about licensing resources available to members of the military and their spouses or domestic partners. The webinar will also feature a demonstration of DCA's Federal Professional Licensing Portal and state registration process, which was launched last fall, as well as a Q&A session. Webinar details and information will be available at www.dca.ca.gov/military. I also want to talk about a new business and travel expense reimbursement program. The State Department of Human Resources, CalHR, recently released an updated travel policy to align with the federal policies outlined by the U.S. General Services Administration. Effective October 1st, 2024, DCA will use the federal standard meals and incidental expense rates for in-state and out-of-state travel. DCA will also use the federal standard and non-standard reimbursement lodging rates. Information on these changes was shared with board leaders at the end of September. Board members are encouraged to become familiar with the new travel expense reimbursement program and rates. Please contact Board and Bureau Relations with any questions regarding these changes. So we are currently in the season of giving, and DCA is honored to join in the annual charitable campaigns launching this month, DCA's annual Turkey Drive and the state's Our Promise campaign. So on November 13th, from 8 until 10, board members and employees had an opportunity to give back to the community. DC held its third annual Turkey Drive with donations benefiting Joey's Food Locker, a local food bank located near DCA headquarters in Sacramento. Donations of frozen turkeys and non-perishable food items were accepted at DCA headquarters, bar headquarters, and Evergreen building locations in the Sacramento area. The items collected during the event are part of a larger state employees food drive that takes place this time of year as well. Later in the month, DCA will announce collection box locations. Every year through the Our Promise campaign, for state employees charitable campaign, state employees, including board members, have the opportunity to support the nonprofit causes that they are passionate about through payroll giving or one-time donations. These contributions have a positive impact on our communities and is another way for DCA to show it cares for California. This year's campaign is led by Monica Vargas, Deputy Director of Communications, and Karen Navarro, Assistant Deputy Director of Communications. DCA's campaign officially launches on November 18th and runs through December 31st. In the meantime, please contact Board and Bureau Relations with any questions or if you would like information on how you can give. Again, thank you for the opportunity to join you today, and I'm happy to answer any questions from the board.
Thank you, Mr. Thatcher. Do we have any comments from board members? Any comments from members in the room? Any comments online?
This is the moderator, and at the direction of the board, we are open for public comment on this item. You can, members of the public on WebEx, you can either request public comment by raising your hand or clicking *3 on your device if you're an audio-only participant. You may also use the question and answer feature down at the bottom right-hand corner of your WebEx screen. All right, and at this time, it appears there are no requests for public comment.
Thank you. Thank you so much for your report.
Thank you.
Next, we have an update from Christian Cox in Harmony Filippo with the Budgets Office at DCA. Virtual.
Kristen, are you able to hear us?
Can we turn a document so it's readable? Oh, okay.
Sorry about that. Thank you, Madam President Pines, and good morning. My name is Kirsten Cox, and I'm a budget analyst with the DCA Budget Office, and I am joined by the budget manager, Harmony DeFilippo. I wanted to thank the board and the executive staff for allowing me a few minutes to present on agenda item 7B, the board's expenditure projections and fund condition statement. First, I'm going to start with the board's expenditures, attachment 7B, page 1 of your materials. These projections are based on actual data through fiscal month 3. This report includes 23-24 actual expenditures in green, as well as 24-25 budgeted and projected expenditures in blue and orange. As we move to the end of the document, you will see the board had a beginning base budget of $4.288 million and is projected to spend a little over $4 million, creating a reversion to the board's fund of approximately $277,000, a reversion percentage of 6.46%. The next document I will be going over is the board's revenue projections, attachment 7B, page 2 of your materials. This report includes receipts collected through September and projected revenue to year end. I will go further into the projections as we transition to the next slide. The next document is attachment 7B, page 3 of your materials. This is the board's fund condition statement. As a reminder, we read this document from top to bottom, left to right. The left column is the board's prior year 23-24 actuals. It shows the board began 23-24 with a beginning base balance of $4.622 million, collected $3.94 million in revenues, with $1.423 million from initial license fees, $2.233 million from license renewals, and $284,000 was collected from the issuance of citations, fines, delinquent fees, and other revenue. The board expended $3.511 million, which includes $239,000 in direct draws to the fund for statewide pro rata and pension payments. The board ended 23-24 with $5.051 million reserve balance, or about 15.1 months in reserve. For current year 24-25, the board projects revenues of $3.914 million, with $1.384 million projected from initial license fees, $2.381 million from renewal fees, and $149,000 from the issuance of citations, fines, delinquent fees, and other revenues. The board's 24-25 expenditures are based on the governor's budget with FM3 projections at $4.026 million between authorized expenditures and direct draws to the fund, leaving the board with a fund balance of approximately $4.9 million, or 12.9 months in reserve. The Budget Office will continue to monitor the board's revenue and expenditures and report back to the board with monthly expenditure projections as we continue to close fiscal months in the current fiscal year. A few things to know of the board's fund condition. The fund condition is a snapshot in time. One of the main factors driving expenditure increases in future years is a result of personal service adjustments. These include general salary increases, as well as employee compensation and retirement rate adjustments. The Budget Office includes conservative ongoing 3% increase to expenditures on the fund condition statement to account for these ongoing incremental adjustments. You will also notice revenue is projected static in the out years. Lastly, I would like to note to the board that any future legislation or unanticipated events could result in the board's need for additional resources, which could create cost pressure on the fund. The Budget Office will continue to monitor the board's fund condition statement and keep the line of communication with the board's executive staff open for any future needs or expectations. Again, thank you for allowing me the opportunity to present at today's meeting, and we'll be happy to answer any questions you may have.
So I have a sort of just like a question generally around like revenue decreasing, but we know expenses always increase, even though we're showing some of these things are decreasing over this budget period. But what are some opportunities that we may have to increase revenue? Because it's pretty drastic if we're looking at actuals today to then what things look like in 2027.
Yeah, I think Harmony will be answering that question for you, so she can give you a little bit more insight.
Okay,
She is on here. I think she just has to be unmuted.
okay. She's going to present that in the next.
No, she can just answer that question for you.
Oh, okay, let's have her answer that question.
Okay.
Good morning. Thank you. So looking at this fund condition, this is based off of our governor's budget revenue. So each year we look at revenue and update the workload revenue. So this does not reflect the current drills that we're going through updating that revenue. So you will see a difference after the release of the governor's budget on January 10th. So that next board meeting after that will have an updated fund condition that shows the updated revenue based off of our current workload revenue assessment.
Okay.
So these numbers could change for the out years.
I think Ms. Calderon wants to make a comment.
Thank you, both Kristen and Harmony. I think I can add a little bit on the budget and what the board staff is doing proactively as well to help increase some of our revenue. We do have a couple of regulatory packets that we're currently working on. And one of them in particular is to increase our application funds, our application due, excuse me, the specific amount for the applications for both the physician and surgeon, full and unrestricted, as well as the inactive status application. So in that area, we do have a little bit of statutorily wiggle room that we have not been charging our applicants. And currently, as we stand, the current application fee is $200 for the physicians and surgeons and $300 for the inactive. And at this point, what we're looking at is increasing it to our statutory cap, which is the $400 and $399 for inactive. So those are a couple of things that we're working proactively. On the enforcement side, we are adding probation monitoring cost to some of our decision and orders. And then the other component on the enforcement side is that we're expanding our authority to be able to cite for more violations. So even though for enforcement itself, we can't really rely on that component to bring in revenue, it is more so on the licensing and application side. Those are a couple of things that we're working on proactively right now to help bring a little bit more revenue to the board.
Okay, that sounds good. Do we have a continuation of the report by Harmony?
No.
Does this conclude your report?
Yes, it does. Thank you.
Thank you. Any comments from members of the board? Any comments from members of the public in the room? Any comments online?
I have a
This
question.
is some
Regarding the osteopathic colleges, do any tuition fees come to the board from their educational expenses or their operating expenses?
No, we actually, the only revenue that we inquire from our applications, our applicants is the application fee, no tuition.
Are there any public comments online?
This is the moderator, and public comment is open for our individuals on WebEx. If you'd like to make a public comment, you can raise your hand, or if you're an audio-only participant, press *3 on your device. You may also use the Q&A feature down at the bottom right-hand corner of your WebEx screen. All right, and it appears there are no requests on WebEx.
Okay, thank you. Christian and Harmony, thank you again for presenting your report.
Thank you.
Hi, I want to recognize that our Vice President has joined us, Andrew Marino. Okay, moving to agenda item number 8, Attorney General's presentation on the disciplinary process. We are joined by Carolyn Westfall, Deputy Attorney General, and Ms. Gloria Castro, Senior Assistant General from the Attorney General's Office. Welcome.
Apologies, Ms. Castro. Looks like you're muted.
There we go. Good morning, dear board. It's always a pleasure and an honor to be able to come to your meetings and have an opportunity to tell you what the Attorney General does on your behalf on a daily basis through people like DAG Carolyn Westfall. Is Ms. Westfall here?
I am. Can you hear me?
Yes. And so we're going to present today. Carolyn is going to go first, but it's my pleasure to give you a little bit of background on Carolyn. Carolyn graduated from the University of California in Santa Barbara, where I went to as well, in 1999. She attended the University of San Diego School of Law in May 2004, and she was admitted to the State Bar of California in 2004. And we've had the pleasure to have Carolyn on our team since 2014. And she will be promoted to a DAG 5, which is the highest level of Deputy Attorney General we have in our office. Prior to joining the Health Quality Enforcement Section, she was a Deputy City Attorney in the San Diego City Attorney's Office, where she worked in many units and focused on domestic violence and special victims units. She routinely presents to the Health Quality Investigation Unit and other investigators on sexual abuse cases. And so she is your liaison. She works very closely with Erica and is always available to answer any questions on an ad hoc basis, and also to help you with programming, trainings and things like that, and presenting what she's going to present today. So without further ado, I'd like to welcome Carolyn, and I want to thank her for all the time she devoted to prepare this presentation for you today. And you may ask questions at the end, and I'll be here as well in case there's anything that is not on the topic that Carolyn is presenting. Thank you very much.
Perfect. Thank you. Good morning, everyone. I don't think I'm in control of the slides.
You should have control now.
Okay. All right, perfect. So thank you, Gloria, for that introduction. So the goal of this presentation is to provide you with an overview of the disciplinary process. Essentially, the life of a case involves various distinct phases, which I'll cover throughout this presentation. The disciplinary process involves the investigation, the referral to the Attorney General's office, the accusation, discovery and settlement, the administrative hearing, the decision by the board, and then the post-decision phase. The Business and Professions Code is the statutory basis for our discipline. The Business and Professions Code section 2450.1 mandates that public protection be the highest priority for the board in exercising its disciplinary functions. And so the disciplinary process is not about punishing the licensee, which of course may be a goal in a criminal case. It's also not about making the victim or patient whole, which may be a goal in a civil case. It's only about public protection. And as we go through this presentation, it's important to remember that goal or purpose in the disciplinary process. So the disciplinary process begins with what we call the investigation phase. The investigation begins essentially when a complaint is received by the board. Now, complaints can come from a variety of sources. Oftentimes, it will be from a patient or perhaps a family member of the patient. And there are some complaints that are statutorily mandated to be provided to the board. For example, if a hospital removes privileges of a licensee, essentially the licensee is fired, that is required to be reported to the board. If a licensee is convicted of a crime, they are required to report that to the board. Or if they settle a civil malpractice lawsuit over a certain threshold dollar amount, that is also required to be reported to the board. Now, regardless of the source of the complaint, board staff is sort of the first stop of reviewing that complaint and determining how that case should proceed. The board staff may decide to just close out that case upon initial review. That would be a very rare situation, and it would be For example, if the complaint came in and it was actually about a nurse or about a physician assistant, the board staff would close that complaint and refer that to the appropriate licensing agency. Most investigations will actually be further investigated. They will be sent out to the Division of Investigations Health Quality Investigation Unit. So that's a specialized unit within DFI that investigates healthcare licensees. In rare cases, our office will participate in investigations with DFI. Usually those cases would be by request of the executive director that we participate. And those oftentimes would involve cases of sexual misconduct that might involve very specific, credibility issues where the DAG would want to, get sort of eyes on the witnesses throughout the investigation, or perhaps a very complex quality of care case that for a variety of reasons might benefit from DAG involvement throughout the investigation. Typically, an investigation will involve the identification of witnesses. Those witnesses would then be interviewed. Most cases will involve the procurement of medical records. So either the patient will sign a release for those medical records or a subpoena will be issued to obtain those medical records. Depending on the type of case, a site visit might occur. Personnel records can be obtained, and the licensee is required to participate in a subject interview with the investigator as well. Lastly, in quality of care cases, once the bulk of the investigation has been completed, that case will be packaged up and submitted to an expert who is in the same specialty as the licensee. And the expert will be tasked with opining whether or not the licensee departed from the standard of care in the treatment that was rendered to the patient. After the investigation phase is complete, the case is then referred back up to the board. The board staff will review it, and if they determine that it's complete, then they transmit it to the Attorney General's office. And so our office, of course, we are the lawyer for the state of California, and within our office is the Health Quality Enforcement section. That's the section that I'm in. This is the section that's assigned to your licensing and disciplinary matters. HQE is comprised of over 40 attorneys statewide, 8 supervising deputy attorney generals, and of course our supervising assistant, Gloria Castro, who you spoke with. And we also have various support staff that help us in our work. HQE was actually created by the legislator to represent and assist healthcare licensing boards. We are required by statute, Business and Professions Code Section 312.2, to publish reports on the accusation matters that we handle for our client agencies. And so we report out on the work that we've conducted. And so, like I said, the board staff reviews the completed investigation and then refers it to our office, where a DAG will be assigned for what we consider the initial legal review and then for prosecution. When a case comes into our office, that DAG will review the investigation materials to determine whether or not there is sufficient evidence to prove the licensee engaged in unprofessional conduct. While looking through those materials, however, the DAG is also looking to see if an interim action would be appropriate in that case. For example, if the licensee has also been charged with a crime in Superior Court, the DAG may recommend that we make what we call a PC-23 appearance in Superior Court, where we would ask the Superior Court criminal judge to initiate an order against the licensee that they be prohibited from practicing medicine during the pendency of the criminal case. Or in some cases, we believe that the conduct is so egregious that permitting the licensee to continue practicing will endanger the public. And so we would recommend initiating a petition for an interim suspension order to immediately suspend the license. We refer to those actions as an ISO. Other than those interim actions, when we're just looking at whether or not to file an accusation, the DAG is looking to see if we can meet our burden of proof, meaning the burden of proof is the amount of evidence we need to prove a case. And the burden of proof in our accusation matters is clear and convincing evidence to a reasonable certainty. Now, what is clear and convincing evidence? There are various levels of proof in our legal system, which you may or may not be familiar with. There's the preponderance of the evidence standard, which is the burden in civil cases, like if a physician's been charged with malpractice. There's the beyond a reasonable doubt standard, which is the burden of proof in a criminal case, say if a physician was charged with assault. And then the burden of proof in our cases, like I said, is that clear and convincing standard. And so understanding the levels of proof, I think, is best illustrated when you look at the scales of justice, which is right there on the slide. When you look at the scales of justice, in their neutral position, they're even. Now, if you place a pebble on one side of the scale will tilt very slightly. And that slight tilt of the scale is the amount of evidence needed for the preponderance of the evidence standard, that standard in a civil malpractice type case. Now, if you place a larger item on one side of the scale, like a rock or a brick, and you cause the scale to tip all the way to the bottom or nearly to the bottom, that's the amount of evidence that's needed in that beyond a reasonable doubt standard, the criminal case. Clear and convincing evidence, our burden of proof, is somewhere between those two. It's more than a pebble, and it's not quite a brick. It's the amount of evidence that it's a finding of high probability of evidence so clear as to leave no substantial doubt. And so that's what the DAG is looking for when they are reviewing the investigation materials. Now, after reviewing the investigation materials, the reviewing DAG has to make a decision about the case. They can decide to just decline to prosecute, and the case would be rejected and returned back to the board staff. This is a very rare outcome of a case, and that is our office saying this case cannot be filed ever. Usually that's because the statute of limitations has expired. The statute of limitations is the window by which the board has jurisdiction over a case. Or upon review of all the investigation materials, our office has determined that there is no violation in this case. There's no unprofessional conduct. Another outcome could be the case is returned for further investigation. That outcome means the DAG has reviewed the case and they've determined that charges are likely viable in this case, but additional investigation will be needed to prove the violation. A case like that may be, well, there's this witness that absolutely needs to be interviewed, or perhaps some medical records were not obtained in the case. Another outcome, which is the most common outcome, would we just accept the case for prosecution. And the last outcome can be we accept the prosecution, we accept the case for prosecution with conditions. In that situation, we are saying we can file charges now, but additional evidence is either appropriate or we believe necessary. So it could be that we say, well, we can prove charges A, B, and C, but if you go and do these few things, we can also prove charges, D, E, and F. Or it could be we can prove A, B, and C, but some piece of evidence is imperfect. For example, I just accepted for prosecution with conditions a case where I reviewed the subject interview recording of the licensee. So I heard it and understood it, but the transcript of that interview was filled with errors. And so that I can prove the case. I know what was said, but that little piece of evidence needs to be completed in order for this case to proceed all the way to hearing. So that was except for prosecution with conditions. After the case has been accepted by our office, the next step would be the DAG is going to then draft an accusation. The accusation is the charging document. It's the document that puts the licensee on notice of the charges against them. An accusation must be filed before the expiration of the statute of limitations. Now, again, the statute of limitations is that window of time that the board has to file charges, the window of time you have jurisdiction over a case. The statute of limitations is defined in the Business and Professions Code, and for all intents and purposes, it must be filed within 3 years after the board discovers the act, or 7 years from the act, whichever occurs first. So if medical care was rendered on January 1st of 2020, the 7-year statute of limitations would expire on January 1, 2027. If the board learned of that care on January 1 of 2022, the 3-year statute of limitations would expire on January 1, 2025. 2025 occurs before 2027, so that 2025 date would be the statute of limitations for that case. Most cases are not that simple. Usually care is rendered over months and years, and so sort of assessing that statute of limitations window is something that the DAG would do in every single case. And of course, there are exceptions to that general rule. The statute of limitations does not apply at all if the license was procured by fraud, or if the licensee intentionally concealed incompetence or negligence. The statute is told if material evidence is unavailable due to an ongoing criminal investigation. And in cases involving a minor, that 7-year period is told until the minor turns 18. And in cases involving sexual misconduct, that 7-year period is extended to 10 years. In either case, however, that 3-year trigger still applies. And so the board must file the accusation by the date that occurs first. The accusation is technically filed when it is signed by the executive director. She sits as the complainant in a case. And so the executive director, Erica Calderon, signs the accusation as it was drafted, and then it is served on the licensee by certified mail to their address of record on file with the board. It is also then published online on Breeze, and that publishing of the accusation is required by statute.
Excuse me.
The Osteopathic Medical Board has to enforce the Medical Practice Act and the statutes that are within the specific section of the Business and Professions Code. A licensee can be disciplined for unprofessional conduct, which is defined in section 2234 of the code, as well as various other sections of the Business and Professions Code. The accusation itself will contain relevant statutes and facts in support of allegations of unprofessional conduct. Unprofessional conduct, as defined in the code, of course, involves those quality of care cases, the gross negligence, repeated negligent acts, incompetence. It can involve dishonesty or corruption, sexual misconduct. It's unprofessional conduct to fail to attend and participate in that subject interview with the investigator for the board. A conviction of a crime substantially related to the practice of medicine is unprofessional conduct. Violation of drug statutes, excessive use of drugs or alcohol. We see that a lot with DUI convictions. Aiding and abetting the unlicensed practice of medicine. We see that a lot with the corporate practice of medicine cases. Record keeping violations, or if the physician has mental or physical impairment. And if it's not actually specified in the codes, we can charge unprofessional conduct under case law if the conduct breaches the rules or ethical code of the medical profession, or its conduct which is unbecoming a member in good standing of the medical profession and which demonstrates an unfitness to practice medicine. After the accusation is filed, the case moves into the next phase of the disciplinary process, which involves discovery, trial setting, and settlement. So that first step after the accusation is filed is the accusation is provided to the licensee with various other paperwork, which one piece of paper in there is called the notice of defense. And we have to receive that back from the licensee. That piece of paper essentially says, I am going to appear in this case and essentially mount some defense against the accusation. If the licensee fails to file that notice of defense in the requisite period of time, the board may proceed by default. The board would then independently determine if there was sufficient evidence to prove the charges in the accusation and can discipline the licensee without considering any potential defenses. More often than not, however, a licensee does file that notice of defense. And once that notice of defense is received, it triggers various rights for the licensee. And so one of their rights is the right to discovery. So upon the receipt of the notice of defense, the DAG essentially turns over all of the evidence in their possession to the other side. If they, most often, physicians have retained counsel, and so then the DAG will interact with their counsel throughout the life of the case. They will provide them with all of the discovery. What qualifies as discovery in our cases is also defined by statute. It's essentially the relevant documents in our possession, which would include evidence of mitigation, rehabilitation, information that could potentially hurt our case. We're still required to turn it over. We don't hide the ball in our cases. And discovery is reciprocal. So the other side is required to give us the discovery in their possession that's relevant to the case as well. They have the right to a hearing on the charges in the accusation. Those hearings are handled before the Office of Administrative Hearings, OAH. They have the right to have representation, but unlike in a criminal case, an attorney is not provided for them. They have to go out and retain their own counsel. They have the right to confront and cross-examine witnesses against them. They have the right to present evidence and testify on their own behalf. And in our cases, if the respondent chooses not to testify, the DAG can actually call the respondent to testify in the hearing as well. So licensees essentially testify in 100% of our cases. And they have the right to the issuance of subpoenas to compel the attendance of witnesses and for the production of documents. After the discovery is exchanged and the hearing is set, the case moves into a potential settlement phase. In settlement, the DAG is essentially assessing their ability to prove charges in the accusation. We no longer have the sort of sanitary investigation that we received at the beginning of the case. We've received discovery from the other side, which would also more often than not involve a defense expert report or evidence of mitigation and rehabilitation that the defense has provided. And so the DAG is assessing the totality of the evidence produced to determine whether or not they can still, prove all the charges. They're assessing essentially the value of the case. What should be the ultimate outcome in this case? The DAG then makes a settlement recommendation to the board's staff, and upon their authority may make a settlement offer to the respondent in the case. Potential outcomes of a case would involve a public reprimand at the very low end of discipline, up to a revocation at the very high end of discipline. More often than not, it's something in between. It would involve a certain number of years of probation and terms and conditions of probation that would adequately address the concerns that were outlined in the allegations in the case. If the parties are able to achieve a settlement, the settlement terms are laid out in a document called a stipulated settlement and disciplinary order. That stipulated settlement, which has been signed by the parties, would then be provided to the board. The board members review it and determine whether or not to adopt it as their decision and order. If you adopt that settlement as your decision and order, it is then served on the respondent and it's posted on Breeze. If you decide to non-adopt that settlement, the case can then be sent back to the DAG and renegotiated to reach another settlement, or it would be set for hearing. If settlement is unable to be achieved, the case moves into the next phase of the disciplinary process, which would be the administrative hearing. Our hearings look very much like any other court trial, with a judge overseeing the case without a jury. Our cases are governed by the rules of the Administrative Procedure Act, which are found in the government code. Our hearings usually involve attorneys on both sides. Like I said, they're heard before the Office of Administrative Hearings and an administrative law judge. Prior to the hearing, the DAG prepares for hearing. So the DAG meets with witnesses, their expert, prepares their testimony, organizes the evidence, prepares an opening statement, closing argument that they're going to give before the ALJ. And then, of course, during the hearing, they present all the evidence and call those witnesses to testify. After the accusation hearing, the case moves into the next phase of the disciplinary process, which would be the decision and order. So for a hearing, after the hearing, the ALJ has 30 days to prepare their proposed or recommended decision for the board. The ultimate outcome in a case is always up to the board. So the board can adopt that ALJ's proposed decision as its decision in order, and then your decision would become final. Or the board cannot adopt that proposed decision. And you can decide the case based upon your independent review of the administrative record. You can ask for briefing from the parties, and you can ask for oral argument from the parties. Or you can remand the case back to OAH with instructions for further proceedings. Or you can adopt the proposed decision with some slight modifications. Regardless of how you reached your decision, once you reached your decision, the case then moves into the next phase of the disciplinary process, which would be what we refer to as the post-decision phase. So when the decision is issued by the board, the licensee then has a couple of options. They can accept the decision and move on. Or they can petition for reconsideration, saying, hey, board, will you look at this again? Would you be willing to make a slight change here? A petition for reconsideration is usually filed with a request to stay the decision, so you have an opportunity to consider whatever they think you need to consider. Usually those petitions may involve some additional briefing, and then you can grant the petition and issue a new, slightly modified decision, or you can deny the decision, and then your decision would take effect. The licensee can then accept the decision and move on, or they can appeal the decision in Superior Court. That appeal is called a writ of mandate. And in those cases, the Superior Court will review the record of the administrative hearing, which would be the transcript of the hearing, as well as the exhibits that were submitted. And they will review briefs submitted by the parties and also oral argument by the parties. And of course, we represent you in those matters. The Superior Court can then grant or deny the writ. If granted, essentially the board's decision would need to be modified in some way, and they send the case back to the board with instructions in telling you how your decision needs to be modified. If the writ is denied, the board's decision then remains in effect. Once that decision is final, again, the licensee can accept the board's decision and move on, or they can appeal the decision in the Court of Appeal or all the way up to the Supreme Court. And the process would then remain sort of very similar to what I explained for a writ of mandate. And we represent you in those matters. So once the board's decision is in effect, and the licensee is revoked or placed on probation, the licensee is then statutorily permitted to file a petition for reinstatement of a revoked license or a petition for modification of the penalty. So if the license was revoked, the licensee can request to have it reinstated after 5 years, except if it was revoked for sexual misconduct, that's a done deal. They can never have it reinstated again. If the license was placed on probation, the licensee can request the board modify the penalty in some way after 1 year, or request early termination of probation after 2 years, or after half the life of the probationary period has elapsed, whichever is greater. And we handle those matters for you as well. And so that's the disciplinary process in a nutshell. And I'm here if anybody has any questions about that.
Thank you, Ms. Westfall, for walking through that level of detail. It was, very clear, I think, about the process. It was really good because we have new board members on, which is one of the reasons why we wanted to have you do this presentation today. So I want to go to my board members and see if anyone has any questions around this process. Any questions, any comments?
Yeah, I had a question. Thanks, Carolyn, for the really good presentation, and congratulations on your promotion. Just something from the front end that was a problem in the past. A lot of complaints would go to the Medical Board of California, and then the complaints would kind of sit there until they eventually got to us. Is that still a problem? And if so, how could we better better this problem or make things more efficient. I would suspect with advances in technology, we could create guardrails where, just a computer program could recognize this person's a DO, not an MD, and you put the complaint into the wrong, place on Breeze. But I don't even know if this is something that Carolyn, you're involved with, or it's something at the very beginning. But I just wanted to see if there was that was still a problem, and if so, how could we better that?
That's probably a good question for Erica, but just to alleviate concerns about that, if a complaint is sent to the wrong board, the board is not technically on notice of that complaint until you receive the complaint. And so even if it goes to Medical Board of California and it's an osteopath, you're not on notice of that statute of limitations trigger hasn't occurred until the complaint comes to you. It's really important that these complaints are time-stamped in some way as well. So when your board receives it, it gets time-stamped. But I think probably Erica has a better answer in terms of how to prevent it from going to the wrong place to begin with.
Thank you. I can definitely step in and answer that question, Dr. Patel. This actually goes back several years, even when I was at the medical board. And I can tell you that a lot of cases were rerouted to the wrong place. They were submitted to the medical board in the beginning. A couple of the changes that we made at medical board when I was there is that we stopped initiating those cases if there were paper complaints from the very beginning, and just package them up and send them right away. So that's sort of a time saver for both medical board staff and ourselves. So instead of them opening complaints, which they used to do, and then track it and close out non-jurisdictional, they just reroute the complaint straightforward. So that's one of the things. The other thing is when I joined this board, I did communicate with Reggie, the EO from medical board, that I had some concerns about us receiving some, cases not in an expedited sort of fashion. And so a couple of the things that we came up with is on their website, we have now a phrase on there to reroute the case over to us. So there's like a bulletin under their complaint licensing tab, and where they file complaints online, and it specifically states that if the case is involving a DO, to file it with us, and there's a link to our page. And vice versa. We did the same thing to help out medical board because, vice versa, we tend to get some of their complaints forwarded to us, and we're doing the same thing. So those are a couple of things that I think have solved the major issue. We are not seeing late complaints coming on our hands. Probably the most that they're taking is about a week to 2 weeks now. And like Carolyn mentioned, the moment that it makes it to our hands, we date stamp it, and that's the day that we have to go by for the statute of limitations. And a couple of other things. Outreach is another thing that we're now more engaging in, and going out to actual, consumer population outreach events, and just putting our name out there and notifying them that there is 2 licensing boards. At this last event that I attended, I actually brought copies of medical board's complaint forms with me as well as ours. And as people were asking questions, we were explaining that there's 2 medical boards here in California and giving them the information for both entities.
Just one more question. Well, I feel like one of the bottlenecks in this process, the process can be pretty long, and that's fine. I mean, we want to do our due diligence, but again, just to kind of create more efficiencies. Carolyn, what I'm trying to say is I feel like one of the bottlenecks is the expert review process, finding an expert reviewer, waiting for them to write the report, and then going from there. I know that's not the only bottleneck, but do we have enough expert reviewers in your opinion? Could we work harder at recruiting more? What are your thoughts on that, Carolyn?
I always think the board can use more expert reviewers, since the expert reviewer has to be in the same specialty as the licensee. And so that can create a delay in obtaining the expert. The experts are usually full-time working physicians. And so they're also, this is some side job that they're doing for the greater good, usually to work for the board. And so cases can turn around quite quickly, but I mean, you're dealing with physicians, and oftentimes a case may involve, 5 patients and the procurement of 5 patients' medical records, and they have to be certified medical records. I mean, it's a lengthy process. But I think if the investigators, work their cases as quickly as they can, they stay on top of the expert to move that case quickly, and then of course, when the case comes to our office, we're also, trying to work it as quickly as we can, because obviously the goal is public protection. And so, we want the licensee to be safe to practice so that other members of the public cannot be potentially injured. But I just think when you're dealing with medicine, it's a complex process. And as I explained, all those phases take time. But certainly having good experts, because if an expert report comes back to us and it's just, sometimes we get reports that just make no sense at all, or the expert clearly didn't consider pieces of evidence that we can plainly review when we review the records, that case has to be massaged some more. We have to go back to the expert and say, did you consider this? Or sometimes an expert may be not even in the same specialty. And that case that's one of those cases that's just kicked back and we need a different expert on this case. And so unfortunately, this does take time, and I can appreciate that the process, is long.
And just to add to that, Dr. Patel, we are working hard to put out the word that we need more experts. We actually recruited close to 50 to 60 consultants because now we have a 2-level review. So it starts at that point with our consultants. They're the ones that will notify us if the case needs to move forward for a formal investigation. So we are putting our efforts out there with our outreach events. We are going to be putting it in our newsletter as well to recruit it and possibly just send out a listserv to all of our licensees to get the word out. We constantly advertise it at our OPSC conferences and our TOPICA conferences that we attend. So we are trying to work more diligently. And, it starts from desk investigation. So we're working on our procedures to kind of tackle our cases faster at our level before they even make it to the field. And unfortunately, when it goes to the field, it's sort of out of our hands in terms of enforcement, but our analysts are working diligently to follow up with the investigators and get timelines as to where they're at with their investigation and to see if we can assist with finding experts. We do work with HQIU, EPU's unit constantly, and our communication with Adriana Vasquez, the supervising manager of that unit who does the recruitment for experts. And we're constantly giving her a list of our updated recruitments that we have done. So they're aware of who we're bringing in so they can utilize our DOs as well. They have, MDs that they utilize for our cases as well. And for the most part, we're not hearing that there's a lot of specialties that we're not finding. They work well with us. It's just a matter of just getting the update and investigations. That's probably the bottleneck, as we would call it. And there's a lot of factors with that, not just the expert procurement, but the caseloads involving the investigations, because we're all sending PA Medical Board and ourselves are sending our cases to them.
I have a follow-up question. Good morning, Carolyn. This is Andrew Moreno. I'm just curious, within your department, what are you finding is the percent of cases that are settled through stipulation versus those that proceed to an administrative law hearing?
I could probably assist in answering that question, Doctor. On an annual basis, we publish a report under Business and Professions Code Section 312.2. And for the most part, we find that on average, we're going to hearing about 12% of the time, proceeding by default in about 8% of cases, and everything else usually will settle. And it fluctuates year to year. So if you actually wanted to drill down on that even further, all of our reports for every single DCA, Department of Consumer Affairs client, are available on the Attorney General's website. And like I said, it's an annual report, statutory annual report that lists each client's volume of annual accusation referrals received, rejected, or returned for more investigation. But to your specific question, it also reports on the averages for processing each stage from A to B to C to completion for the bulk of cases adjudicated annually. And it's a public report. It's very transparent. It shows our accountability for the Attorney General's office and helping you to protect the public, which we take as seriously as you. And it shows how we manage our accusations for the clients. And you can find the latest 2024 report at oag.ca.gov /publications. And you would look under the Civil Law Division. And I'm more than happy to send a copy to Ms. Calderon and she can, share it with you if that's the more efficient way to answer that question.
I appreciate that. Thank you.
Just to give you an idea, Andrew, in the last 2 years, we've only had one PD. Most of our cases here at the board for the last 2 years, at least since I've been here, have been through settlements.
I have a follow-up question. This is Brett Lockman. Thanks for the excellent presentation, Ms. Westfall. What is the Attorney General's office role in, let's say, corporate practice of medicine or practice of medicine without a license? Is it the same standard of clear and convincing evidence? And then what is the reciprocal role of either of the two medical boards in assisting in that investigation if that is under the purview then of the Attorney General's office, or who takes care of that?
So practicing without a license is not unprofessional conduct, since we are disciplining a licensee. So if you don't have a license, we're not involved in that. That can be charged as a crime. I know HQIU does investigate those cases and can submit it to a district attorney's office. And so, of course, a crime would be that beyond a reasonable doubt standard. The corporate practice of medicine is unprofessional conduct under the code. And so that would, when we're talking about corporate practice of medicine, a very sort of bread and butter type case that we would see are these med spa cases. Where the physician has essentially is overseeing some med spa in some way, but isn't actually practicing the medicine, some other nurse or something. And so when you're involved in the corporate practice of medicine, the physician is required to own 51% of the corporation, of a medical corporation. And when that's offset and someone else is either owning 51% or more, or in practice is essentially owning 51% or more, the licensee is on the hook for that corporate practice of medicine violation, which we usually charge as aiding and abetting the unlicensed practice of medicine, which is a separate charge in the code. And so all of our charges of unprofessional conduct require that clear and convincing evidence standard. The corporate practice of medicine cases can be incredibly complex to prove. And those are some of the types of cases when I was explaining in my presentation that sometimes a DAG is asked to be involved in the investigation. Those are the types of cases that sometimes we get asked to be involved in. Did that answer your question?
Yes. I guess my question beyond I know you're involved in potential discipline of the physician that might be involved, but what about the non-physician members, let's say, of a corporate practice of medicine case where you have, property owners or, administrators and accountants and that sort of thing, where they're running a clinic or what have you, and the doctor may be an incidental, hapless victim, him or herself, not quite realizing that he or she's involved in corporate practice of medicine. Who disciplines the non-physician members?
Right. So if they are a licensed person, frequently, again, it's a nurse, let's say, those cases would and should be be referred to that licensing board. If it's a non-licensed person, the licensing agencies don't have jurisdiction to do anything to those non-licensed persons. And so that would be could be considered the unlicensed practice of medicine, which is a crime. And that goes to a district attorney or some other prosecuting agency. Again, we don't have jurisdiction over that non-licensed person.
Thank you.
Mhm.
With the expansion of our site authority, Dr. Lockman, we will have eventually the authority to be able to cite for unlicensed practice. Currently, we don't. And so that is one of our, goals with this new reg packet. It is expanding it to be able to take action on any violation, including unlicensed practice. And that would become a priority for the board to try to do it at that level, help educate some of these individuals. But like Carolyn mentioned, most of the time right now, how it's being handled, it is usually a PA or a nurse or even BB and PT, licensees that we are working and referring those cases over to.
Do we have any further comments from board members? Any comments from members in the public that are in the room? Comments from the public online?
This is the moderator. At this time, we are open for public comment. Members of the public on WebEx, if you would like to make a comment on this item, you can raise your hand or use the Q&A feature down at the bottom. And it looks like we do have a couple of people who have requested public comment. One moment while we go in order. So first I have Michelle Montserrat Ramos. You'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device. And Michelle, you are unmuted now.
Good morning. I am Michelle Montserrat Ramos, and I am with Consumer Watchdog. Thank you for your presentation. Our team members and the many families we work with have had many questions about the process that the AG's office follows. One aspect of the process you didn't mention was when the complainant is notified of a proposed settlement, because many times this is not occurring. There have been a number of times when a family is notified by a member of the public. There have been cases where the enforcement process has not been followed as we know it and as you describe it. In the Central Valley, we had complaints that were filed during the last administration under the leadership of the prior executive director, where staff contacted your DAG and your DAG recommended that the complaint either not be reopened or not pursued because it wouldn't matter. When it was a problem with the prior OMBC staff contacting the DAG initially, instead of submitting the complaint into the process and reviewing it, that was a problem. Secondly, the DAG denied families the right to the special statute of limitations for minor children. One baby was denied this right, and another child who survived was denied this right. There is a mom out there who is providing 24/7 care for her child who will never be able to walk, is on a feeding tube, and is still enduring surgeries 9 years later. The problem was that the cases cited in the closure letter to these families cited family law, which isn't relevant to the proceedings of this board. He cited case examples where the person that harmed the child was a parent to the child. How is that relevant? Obviously, the doctor that harmed these children was not the parent to these babies and was not in an intimate relationship with the mothers, one who died and one whose life is dedicated to the 24/7 care for her child. There was no due process for the families in these cases. Because there was no due process and these cases were closed, other mothers were later harmed and other babies died after these cases were closed. We understand the problems with the prior OMBC leadership and believe that will not happen again under the leadership of Executive Director Calderon. But the issue of the DAG issuing recommendations to close complaints and not reopen complaints that had merit, that were supported by investigations by other entities, has not been addressed. The outcome was that these death complaints and long-term harm complaints were closed without due process for the families. This has not been addressed, and the families want answers. They should not have to pay for misconduct. Grant these families.
All right, and time is up. We will be moving on to our next individual who has requested public comment. Tracy Dominguez, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
And I am a volunteer with Consumer Watchdog. I have been looking forward to this presentation because 2 failed cases with this board, which one linked directly to the AG's office, have kept me in front of this board seeking change and demanding answers. I filed 2 death complaints on behalf of my daughter and the other one on behalf of my grandson. With my daughter's complaint, I sent in findings from the Department of Public Health. The findings came back with my complaint was already in process. I kept in contact with the enforcement staff and responded back with documentation that included the statement of deficiencies and supported my complaint. The staff sent my documentations to the DAG, Vladimir Shankovich. Vladimir's response was that it wouldn't make a difference and to close the complaint. We argued the documentation with this board for 9 months, with the board staff acknowledging that he agreed with us, but the DAG had made the decision. This was a repeat offender doctor, and it was not the first time that Vladimir had interfered in a Central Valley complaint. Vladimir has also interviewed in another Central Valley daughter's case. The Central Valley daughter was harmed during birth. She survived and is 9 years old. She will never be able to walk or feed. She's on a feeding tube and still endures surgeries 9 years later. She was denied the special statute of limitations to minor children, along with my grandson. Vladimir cited example of this case where a child was harmed, where a person was linked to harming was either the mother or the father to the child. This had nothing to do with the doctor-patient relationship. My grandson and this young 9-year-old daughter were denied the special statute of limitations by your DAG, citing the president, and had nothing to do with how my grandson died and the other Central Valley child received long life harm. We need answers. These are not only the cases that the DAG had intervened with. Repeat offender doctors to continue practicing and continue to harm additional mothers and babies, leading to more deaths in the Central Valley. We need answers, and if this needs to occur outside of this meeting, then I am ready and willing to make myself available to discuss and work on this issue. Thank you, and I do hope that you attend my event in May.
Seconds.
Like you said, you're attending events to give the public knowledge of your participation and resources to them. Thank you.
All right, this is a moderator. We will move on to our next individual, Maria Ibarra Navarrete. And Maria, you'll be given 3 minutes to speak with a 15-second warning. Please click the unmute me button when the prompt appears on your device.
I'm a volunteer with Consumers Watchdog. I'm one of the Californians who was failed by this board. More importantly, my brother was failed by this board. I filed a death complaint on behalf of my brother Jose. When I filed my complaint, it was before I had received the final result of his autopsy. Furthermore, I did not have the results from the Department of Healthcare Services investigation. That will later unfold the truth of what was happening within the facility where medical professionals were caring for my brother. My issue was that I received this information after I submitted my complaint, And the process to submit this critical additional information that would support my complaint was something I had no idea I could do until I called the analyst and asked, what is the current process available for me to resubmit a complaint and get it reopened, get my case reopened? And what is the appeal process for the complaints? Although I believe that the process is being followed now under new leadership, I share my fellow advocates' concerns that our complaints were not handled according to the process under the former administration, and my brother's death complaint went unanswered due to the failures of the prior administration. I understand that this system board follows different laws than the criminal justice system. However, I cannot help and say when the criminal justice system fails, there's an appeal process with exact language stating the decision of the courts and reopening cases. Now, when it comes to our medical justice system, the transparency is vague. I was left with many unanswered questions to the conclusion of why my complaint was being closed. In an email to the analyst in my case, I requested an explanation to the decision that the medical expert concluded, and why was the physician in question not in violation under negligence per se. But I never received an answer. How do we ensure that our complaints receive the proper review and assessment? What are your comments about the official process and how we officially appeal these complaints? Thank you.
Moderator, is that the last speaker?
I apologize. I was on mute. Yes, that was our last speaker, and it appears we have no further requests.
Okay, thank you. Thank everyone for their comments. I want to thank Ms. Westfall and Ms. Castro for joining us and outlining the process. That was very important, and I'm glad that it's on the record.
Thank you, President Pines, and thanks again to Erica Calderon for inviting us to assist you. It's a privilege and honor to be involved in the protection of the health and safety of California consumers. Thank you very much.
Thank you. We are now going to take a 15-minute break. It is 10:32, so we'll come back 10:45-ish in seats. Thank you. Welcome back. I'm glad we're enthusiastic on our board. It's great. Let's start with agenda item number 9, Executive Director's Report. Ms. Erica Calderon.
Thank you, Madam Board President. Good morning to all, Vice President Moreno, Secretary Adamian, board members, council, and staff. Before I get started today, I would like to take a few moments to wish you all a very happy holiday season with your loved ones, and also take the moment to express my sincere gratitude for all of your hard work throughout the year. It's been 2 years this month since I became your executive director, and I couldn't be more proud of where this board stands today. My report today is intended to provide the members of the Osteopathic Medical Board with an update on personnel, other administrative functions, and projects occurring at the OMBC. And no action is needed at this time. In terms of personnel, the board has 15.9 authorized positions, and it is happy to announce that the recruitment process on its newest associate governmental program analyst positions completed this past quarter. As previously reported, the board received 2 enforcement AGPA positions pursuant to SB 815. And as of today, the board is able to report that both analysts, which required very little training, are managing their own caseloads for enforcement. I will start by formally introducing you to Ms. Christy Livramento, who is present here today And you will hear her give the enforcement program update later. Christy, if you can please raise your hand so the members can see you. Ms. Livramento joined the OMBC family on August 30th, 2024. She holds a master's degree in business management from Pittsburgh State College and a bachelor's of arts degree in women's studies from the California University of San Marcos. Christy started her state career as an office technician in the licensing unit of the Physical Therapy Board of California in 2008. In 2009, she promoted to a management services technician handling criminal conviction cases, and in 2010, promoted to staff services analyst. In 2012, she promoted to an associate level analyst, where her caseload grew to all case types, and eventually became PTBC's lead enforcement analyst. Christy has over 16 years of enforcement experience, and in such a short period of time has already proven to be a huge asset to the OMBC family. Because of Christy's background and experience, she's currently assisting me with many of enforcement's administrative functions, and I personally couldn't be more grateful for her assistance. Please join me in welcoming Christy to our OMBC family. Next, we have Ms. Gloria Laughlin, who is virtually in attendance with us. She joined the OMBC family on September 3rd, 2024. Gloria started her professional career at Wells Fargo Bank in 2014 as a consumer services representative for a little over a year, and in 2016 started her state career with the Department of Motor Vehicles. In 2019, Gloria became a licensing evaluator for the Board of Vocational Nursing and Psychiatric Technicians, also known as BVMPT. And in 2020, she transferred to the Board of Registered Nursing Enforcement Unit as a staff services analyst handling all case types. Gloria joined our OMBC family on a promotional opportunity as an associate analyst, and like Christy, has already proven to be a huge asset for this board. Please join me in congratulating Gloria on her well-deserved promotion and welcome her to our family. For office operations, I have a couple of updates. The board continues to work diligently on office and program specific improvements. As previously reported, the Administrative Services Program has completely gone paperless with all of our licensure transactions and applications, which include name changes, address changes, license verifications, and most recently, our fictitious name permit applications. Application staff continue to work diligently to expedite all of the military spouse, underserved, and asylum applications. Overall, they are well under the targeted 60-day processing time for both application types, a huge improvement from being 8 months 2 years ago. And lastly, I am happy to report that all of SB 815 mandates for the enforcement unit have been implemented. This includes patient impact statements, which this board operated to choose that as an optional. The consumer interviews on all quality of care complaints alleging negligence or incompetence. The subject interview mandate that our licensees submit to an interview process within 30 days from being contacted by an investigator, and the complaint liaison requirements, which this board will handle through a rotational enforcement analyst, which we are calling the CSA of the week. In terms of our expert reviewer training on Saturday, August 17, 2024, the Medical Board of California hosted an expert reviewer training session, and all of OMBC's experts were offered the opportunity to sign up and attend the training. The board is happy to announce that 15 of its own experts attended the training, and OMBC received great feedback. The board would like to take an opportunity to formally thank Mr. Reggie Vergassi and the Medical Board of California for allowing our experts to attend their training until we develop our very own. On September 26, 2024, the OMBC officially joined IMRA, the International Association of Medical Regulatory Authorities. And I am happy to announce that I attended my first webinar at 4 a.m. in the morning on October 22nd, 2024, titled Getting the Most Out of IMRA Physicians Information Exchange, PIE. On September 27, 2024, the OMBC and BRN entered into an MOU, this is Board of Registered Nursing, which is allowed by Government Code Section 1181 Subdivision G. Both parties agreed to share with each other the information each party receives if the information or the subject thereof falls within the scope of their licensing and enforcement responsibilities. Each party authorizes the other party to use the shared information for the receiving of parties' licensing and disciplinary investigations and proceedings. Having this MOU in place allows for faster exchange of information between the two boards and in turn faster and greater consumer protection. Terms of our diversion program contract with our vendor Maximus, as previously reported, the board, along with other Healing Our boards, were in the middle of renewing our diversion program contract with our vendor Maximus. Our current contract was due to expire this December, and on August 26, 2024, the board learned that Maximus did not anticipate submitting a bid for the contract this year. And on October 18, 2025, a notice of intent to award the contract to a company called Premier Health Group was made public. The board will continue to work with DCA to transition all participant information to our new vendor. However, please note that in the meantime, Ralph, our probation monitor, will continue to monitor each participant very closely to ensure compliance with our participants' contract agreements and their decision and orders. For technology, the OMBC continues to monitor the updates and development of Medical Board's phone app. As previously reported at other meetings, Medical Board was hopeful to complete their phone app updates at the end of this fiscal year. So the plan is for us to continue to monitor their progress and report that back to this board. Just as a reminder, our hopes are that we piggyback on their app and that we create our very own. We are also looking at Android options. In terms of cures, I do have an update effective April 1st, 2025. Our cures fees will be increasing once again from $9 annually to $15, which means that our licensees will now be paying $30 biannually for cures operations. DCA's Office of Information Services, also known as OIS, will be working on implementing the cures fee increases to our applications in Breeze, and will be reaching out to each and every single Healing Our boards who licensees pay into the cures system. Our applications will be updated to reflect the new fee increase, and DCA will develop an outreach toolkit to share information with our licensees and our stakeholders when the time comes. In terms of communication, the executive director had calls and exchange with Madam Board President Denise Pines to discuss pending and ongoing projects and meeting agendas. The executive director continues to meet periodically with the board's attorney general, Ms. Caroline Westfall, and also communicates frequently with Ms. Gloria Castro, Senior Assistant Attorney General, who just gave a very informative presentation on the disciplinary process. Thank you, Ms. Westfall and Ms. Castro, as always, for being very open and helping OMBC with AGO matters. The executive director continues to meet with our Division of Investigation Office to discuss progress on pending investigations. One of the areas that I will be monitoring closely is the cost associated with our budget for this line item, as the board is now sending a lot more cases to the field for formal investigations. On September 30th, 2024, the executive director met with Michelle Montserrat Ramos and Maria Ibarra Navarrete from Consumer Watchdog Group to discuss board consumer complaints virtual tutorial video. The board will be taking into consideration their input provided by both Ms. Ramos and Ms. Navarrete. And as progress is made on the video, the board will be provided with these updates. The board hopes to have this video produced by the end of this calendar year. I'm also happy to report that other enforcement program enhancements came out of this meeting with Ms. Montserrat Ramos and Ibarra Navarrete, such as an analyst introductory letter, which you will hear more about in the enforcement program update. Lastly, for communications, board staff participating in meetings with other local, state, and national organizations and discussing and deciding regulatory measures common to OMBC and others. These organizations included, but were not limited to, the Office of Attorney Generals, Department of Justice, DCA, other Healing Art boards, California Department of Public Health, California Department of Healthcare Services, the Federation of State Medical Board, the National Board of Osteopathic Medical Examiners, MBOME, International Association of Medical Regulatory Authorities, Osteopathic Physicians and Surgeons of California, and Maximus. For my outreach update, in terms of outreach, which is my last topic to be updating you on, the board's second edition of its board's newsletter, Osteoscope, was published and was posted on the board's website and shared with all of our stakeholders. These were a hot commodity at some of our outreach events, so we will be publishing more just hard copies and carrying them with us at all times. On September 6th through the 8th, the board attended the Osteopathic Physicians of Surgeons of California 34th Annual Fall Conference in Monterey, California. The board hosted a table throughout the conference and was able to answer licensing and enforcement related questions and provided the board, and we were able to provide an update on the board to all of the attendees as well. On October 12, 2024, Machiko attended the California Health Sciences University residency fair at CHSU. Machiko was able to host a table and answered questions about the licensure process to all of our PGY students. On October 24, 2024, I attended and hosted a table at a community health and resource fair hosted at Selma Senior Center located in Selma, California. I was able to speak to our consumers about the DO profession and the importance of being an informed patient. Lastly, I hosted a professional identity class targeted to second-year students at Touro University, along with Dr. Elaine Ho and Dr. Alicia Wagner, and Machiko and I will be returning back to the university on November 25th, as students will be presenting their very own presentations to the board and reporting back on what they learned in terms of the disciplinary process. At this time, this concludes my executive report, ending the 2024 calendar year, and I'm happy to answer any questions the members might have.
Just a couple comments. First, I want to welcome Christy and Gloria. We're very excited to have you join the board. When I first came onto the board, we had 10 members of the team, and now to be up to exciting. Is exciting, and I know that, you know, this board is flourishing, and I'm excited about what we can do as a board. At the end of the board meeting, we'll be putting together some committees so that we can help support the work that you're doing. So I want to see if there's any board members that have any comment on the report that was just provided by our executive director.
Just a quick question. In terms of for the diversion program, I know it's coming to an end next year. How do you envision any contact with the new organization that's going to be managing the diversion program in terms of communicating with them so that we can have a smooth transition?
Thank you, Andrew. It actually ends this December. Yeah, so we have been meeting, DCA leadership, all the Healing Arm Board's executive directors have been meeting with DCA and Maximus currently on a weekly basis. And we're working that transition as we're speaking right now. So they've reported to us just yesterday that all of the data in terms of the participants has been transferred over to DCA. And so we are essentially getting prepared to make that transition effective January 1st. One of the things that we're also working on for this board, just to have a safety measure in place, is we're getting our own contract with a testing vendor so that Ralph himself can go ahead and test some of our probationers directly. And so we wouldn't have to use an outside vendor for those services, just so that we have this, the safety measure in place. But as we're speaking, we're meeting, constantly with DCA right now, leadership. Their OIS team is working with Maximus as a, technology team to just make the transfer smoothly. And our hopes are to get, up and running. One of the things that I was able to sit on was actually grading the new vendor and making sure that they meet our requirements. And so they were able to pass in terms of everything that we are requiring of our, current contract vendor that we're seeking out. So they met the criteria of putting that in paper, that they are going to be meeting our expectations and our mandates in terms of our program.
Great, thank you for that feedback.
Are there any other members that have comments or want to speak?
That was a question.
Yes, please.
That is really hard to kind of put into content right now, Gore. Essentially, the next step for us to wait on is for medical board to give us the green light that their updates have been established with the current version, which is the iPhone version. And then the next step is for us to put in a project with DCA's office that handles these types of technology projects, and work with medical board. Medical board was willing to give them their platform, as I'm not sure if everyone knows, but I should probably disclose this. Medical board has their own IT department, and they have their own staffing that handles most of their website designing, all of their technology. And so we don't have the luxury of having that at this board because we're such a small department. So we have to use those resources from DCA to help us in gaining, such programs. And so once medical board gives their information over to DCA, we can then move the project along. This, I can tell you that approximately a project this big can take up to 1 year to 2 years to complete. And Ms. Denise Pines, you were at medical board when this was developed, right? So maybe you can provide a little bit of insight on how long it took for them.
Yeah, it took a while for it. It was something that had been worked on for a while. But the rollout was really great. It was a, really big campaign around it, and people really appreciated having the ability to have something that was initially you're proactive, meaning you have to put your information into it, but then it's automated once you do that in terms of updating you and letting you know any change status on the physicians that you actually put in there. And you can monitor, I think, up to 16 physicians, which meant you can put your children's physicians in, your parents' physicians, and any other person that you want to monitor around changes with regards to their physician. So it's really, I think, a great way for people to be connected to their physicians in a different kind of way. And that, initially, like I said, they're proactive, but then it's automated. So you don't always have to feel like people keep checking to go to our website. So that's one of the reasons why we think that this would be advantageous to the public. And why we are staying on top of making sure that this happens.
Thank you.
Mhm. Is there any other? Yes.
Yeah, I want to congratulate you on making such great strides and increasing our presence in the community. And I know that we have future meetings at schools. It would be great to hopefully engage students as we have our meetings at the schools. I know previously I made a comment in Fresno, where are all the students? So I know they're busy, but I think it's really important for students to understand what this board does and how not to get in trouble, because the perception, and I can speak as a former student, is that the board's going to come after you if you do X, Y, Z. If you write something in your note that, you know, blah, blah, blah. That's not true. I feel like we really need to kind of work better at engaging our students.
Yeah, Dr. Patel, and I can add to that, you know, this presentation that I just did at Touro University kind of gave me a good eye opener on how much they don't know about the board. And they know, you know, about the association, but they don't know the difference between what the board does versus the association. So I was able to explain that. We did case example reviews that they loved to hear. They, you know, their eyes opened up when they were like, wait, we have to worry about competitors sometimes too. They would be the source of this complaint. And so things like that, I think it also, you know, puts into play, like, you know, one of the things that I explain to them is just communicate with the board, answer to the board. We're also here to educate. So even if we do find that there was a deviation, you know, we start off with educating. No, we don't automatically just take action. And so a lot of the times it's just, you know, the education component and, you know, making sure that your record keeping is up to par, that you're keeping up with your CME so that you are, you know, at par with what the recommendations are for the standard of care. So it is something that we're going to continue working, Machiko and I, towards and getting more involvement, but also at the board meetings, we are asking the deans to make it a point for them to attend the board meetings, see some of the petitions. Ralph actually has a couple of petitions in line for you guys in the near future. So that would be a great opportunity for them to come and see how that process works. And we are establishing great relationships with the deans, and they're, you know, wanting this as well.
Great. Any other comments from board members? Any comments from members in the audience? Any comments from members of the public online?
This is the moderator, and we are open for public comment on WebEx. If you would like to make a comment, you can click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And audio-only participants may raise their hand by pressing *3 on their device. And it looks like we do have a couple individuals requesting public comment. First, I have Maria Ibarra Navarrete. And Maria, you will be given 3 minutes to speak with a 15-second warning. Please click the unmute me button when the prompt appears on your device.
My name is Maria Ibarra Navarrete. I am from San Jose. I'm also a volunteer with Consumers Watchdog. We are very happy to see that this board staff conduct public outreach out in the community in Salama, California. The public is not aware of this board and the services it provides to the public. Thank you for this outreach. We look forward to future public outreach in the community. I would like to also thank Executive Director Erica Calderon for reaching out to our team to meet with us and seek our input on your future consumer complaint virtual tutorial video. We appreciate your executive director's willingness to work with the public and believe that our input provided a different need perspective on behalf of the consumers who will watch the video and use the video to assist them in filing their consumer complaints. Thank you again.
All right, this is the moderator. Next, I have Michelle Monserrat Ramos. And Michelle, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device. All right, Michelle, and you are unmuted.
I am Michelle Montserrat Ramos, and I'm a consumer watchdog. We appreciate the work that your executive director and this board has done to implement our SB 815 legislative priorities. We appreciate that you have implemented the patient impact statement, when you weren't required to. Then your executive director took a step further and compiled a complainant handout to describe what a patient impact statement is and the type of information the board was looking for, which we hope will encourage more complainants to submit a patient impact statement to this board. We are pleased that your executive director has already begun conducting complainant interviews before consumer complaints are closed by this board. This is a very important consumer protection that this board has already initiated, while the Mega Board of California has not started the process. As mentioned in this report, your executive director invited our team to discuss the production of the upcoming How to File a Consumer Complaint video. We appreciate her willingness to work with the public and get our input on the tools that the public uses to file a complaint. We had a productive meeting where our input led to some changes to the board's letters to consumers that will help complainants, but should also help save your time, staff time as well. Finally, we were pleased to see that your staff was out in the community doing public outreach at a health and resource fair in Selma. The public needs to know what services you provide them and that you exist. At Consumer Watchdog, we promoted your outreach event on all of our social media platforms, and members of our advocacy team did as well. This is a good step at communicating with the public, and we look forward to more public outreach conducted out in the community. Thank you.
All right, this is the moderator. Next, I have Tracy Dominguez, and Tracy, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Hi, I'm Tracy Dominguez. I'm a volunteer with Consumer Watchdog. I would like to thank Executive Director Calderon for implementing the patient impact statement. When we came before the MBC and expressed that families were not submitting patient impact statements, your Executive Director heard us and created a handout which is sent to families. We hope that this handout will help families understand the importance of submitting a patient impact statement. We are happy to see the board has already started this, interviewing families before their complaints were closed. Had I had the opportunity, I would have been able to fight for my complaints to be that were closed. I was one of the team members that fought for other families to have the right that I did not have. Thank you, Executive Director. The foundation has already said these interviews are taking place for families now. The medical board has not taken these steps yet, and families' complaints are continued to be closed with no interview before the cases are closed. We were happy to see that your board staff member was conducting an outreach in our communities at the health fair in Selma last month. That is so important to be out there in the community, letting families know that there is a board that exists that services there and provides information. We are looking forward to seeing you in the future at our events. Hopefully, you will consider coming out to our annual health fair. Thank you very much for listening to us.
All right, this is the moderator. Appears there are no further requests for public comment on WebEx.
Thank you. Thank everyone for their comments. Thank you, Ms. Calderon, for your report. We are now going to move to agenda item number 10, licensing program update from Dina Rupert, the board's licensing program analyst.
Ms. Pines, and if I can actually ask all of the licensing staff here present to come and just quickly introduce themselves. I think we're going to do this for every program update. Thought it would be a good opportunity since we have new board members, and I don't know that you ever have been introduced formally to any of our staff, so they're all here. I asked them to be here present and just kind of say a few words of how long they've been here with the board, and maybe you guys want to start right ahead, Dina.
Good morning. Good morning. I'm Dina Rupert. I've been with the Osteopathic Medical Board going on 8 years in January. I've learned so much when I started there as a receptionist. Angie Burton taught me how to do the licensing, which I've enjoyed, and Erica and Machiko continue to teach me new things. They're always willing to listen to any thoughts or ideas that I have and always give me positive feedback and vice versa. And I really enjoy, especially working with the doctors, seeing what they do and what they need from us. And it's really enjoyable when we do these outreach programs with them. They don't know a lot, and then they're just like, oh, okay. And, I do the PTL, so we're coming to the end of them having to get their PTLs, and now a lot of them are stressing out because they waited till the last minute. And, they're like, well, we don't have time. I'm like, well, at the end of December, you will have plenty of time to get me everything you need to get that license. So it is really enjoyable working with them and seeing what they go through. Thank you.
Thank you. Hello, members. My name is Gabriela Gonzalez. I'm with the licensing, the full unrestricted license applications. And I've been with the board almost 2 years, coming in January. And I handle all the Alpha A through L for licensing applications.
Say your name one more time.
Gabriela Gonzalez.
Gabriela.
Hi, I'm Mia Quinn, and I've been with the board for a year, and I'm a licensing analyst.
Thank you. Thank you, Mia. Okay, Dina?
I'm here with the licensing statistics, attachment 10A and 10B. Provide a snapshot of the licensing population and application status for the first quarter of the 2024-2025 fiscal year. There are currently 15,840 licensed osteopathic physicians and surgeons, 1,149 postgraduate training licensees, 1,314 fictitious name permits, and 1 temporary osteopathic physician and surgeon license. On attachment 10B, you will notice that the board experiences a substantial decrease in the receipt of applications between the current and prior fiscal year. Yet the current fiscal year data provides a true representation of the board's general workload. The licensing unit underwent numerous changes during the 23-24 quarter one period. The noteworthy addition of the physician and surgeon license application to the Breeze VO portal. In addition, the licensing unit is currently averaging a 25 cycle time when processing applications with no deficiencies, where the board's allotted target time is 60 days. Program review. Now that the peak application periods have passed, the licensing unit will focus its attention towards continuing to create content that will assist and educate prospective applicants on the application process and licensing requirements. This content will be made available on the board site and eventually shared through each of the board's social media platforms as well. In addition, the licensing unit is thrilled to report that more requests are coming in asking the licensing unit to participate at student outreach events. Recently, Machiko participated at California Health Science University Residency Fair and OPSC student track event, speaking to students at both and giving insight on the things they should keep in mind when applying for licensure. Our hopes are to continue working closely with California programs and osteopathic schools to educate students and programs about the board's processes. Is there any questions?
Thank you.
I had a question about.
Go ahead, please.
10B. You mentioned the 83% decrease in the total applications from physicians and surgeons. Is that just an aberration because of the process changes, or was something else behind it?
I'll go ahead and answer that. There were a couple of things. So there was a change in management and oversight for that section. And unfortunately, at that time, we had quite a few paper applications that had not been keyed into the system in a proper manner. So we had roughly a 250-day lag in our processing times. But we went live with the online application in August. got all of those input into the system. And so the brunt of the onus for entering all of the data was now on the physician as opposed to the staff in office who was manually keying each and every application into the system.
Okay. So do we expect those numbers to normalize?
Yes, we've normalized the numbers. So this is about the average intake for a quarter, about 300 to 400 applications.
Mr. Cummings, we knew that this was going to kind of be something that would stick out like a sore thumb to all of you in this report, because it essentially kind of looks like it's a bad thing, but it really truly is not. As a matter of fact, it's a great thing. And Machiko and I were discussing this even last night on how we were going to, pitch this to you all to kind of give you the overall image of what was really truly going on. So as you know, we had quite a backlog of applications when we, a couple of years ago. And so as Machiko mentioned, staff were keen in every application. So these numbers here from 2023, 2024 fiscal year still reflected the keen in of those applications that were just sitting in our office, not being processed. And so establishing a unit with an oversight manager that handled the process changes, which also helped us go live and paperless, was the major key component. So these true numbers here, the 361 applications for physicians, surgeons, that's what we expect going forward. And those are true numbers that are being reflected in the Breeze system, with the analyst now verifying the information that's inputted by the applicant and not them themselves having to input the information. So the 659 were applications that were paper applications that were still getting inputted. And we're talking about months of being behind. Like I mentioned, we were roughly averaging 8 months in 2022. When I first joined. And now, as Dina reported, we are at 25 days, you said, which is amazing. Our procedure, DCA calls us to have it under 60 days. And so if there's no deficiencies, we're at 20, which we can continue to improve a little more, but that's, we're meeting our mandate.
I want to thank you all for working so hard, because I'm a licensee too. And I have used the online system and it's really easy and user friendly. I did want to ask though, are we still auditing all the CME, 100% of it, or are we getting close to a point where we can do random audits at the back end?
We have a surprise for you later.
Keep asking that.
Terry will actually be providing an update on our regulations. Happy news, happy news.
Are there any other comments by board members? Any comments from members in the room? Are there any members of the public that want to respond online?
This is the moderator, and I have opened up a public comment on WebEx. If you would like to make a comment on this item, you can raise your hand by clicking that raise hand icon. If you're an audio-only participant, you may raise your hand by pressing *3 on your device, or you can use the Q&A option down at the bottom right-hand corner of your WebEx screen. All right, and seeing no requests, believe that is it.
I want to thank Dina and her team for coming and introducing themselves and for us to know who they are, the wizards behind. So now we're going to move on to agenda item number 11, Administrative Services Program, presented by Terry Thorpenson, our Administrative Services Manager.
Thank you, Madam President. I'd like to ask my admin program services staff to come up to introduce themselves before I go into the actual update report. Microphones are on, just lean into them. Go ahead, Andrea, you can start.
Good morning. Can you hear me okay?
You can.
Good morning. I'm Andrea Harmon. I have been with the board since October of 2022. I'm a staff services analyst and serve as enforcement intake and carry my own caseload. I also audit the fictitious name permit applications and service backup, and will also be serving as backup to the renewal applications as well.
Hi, my name is David Moran. I've been with the board since August 31st, 2001. I do renewals and CME compliance.
My name's Jaime Nichols. I've been with the board since January 2014, and I also do renewals and CME compliance.
Hi, my name is Sanjay Naresh, and I'm the current office technician. I've been with OMBC for 11 months, almost going on a year. Excited to meet all the new board members and Denise Pines. I do various things from license verifications to fictitious name permits, address changes, name changes. I answer all the calls, trying to make the consumer feel comfortable, triage the calls to all the experts on this panel and behind. My coworkers, not my employees. I've learned a lot in these 11 months. And for me, the motivation to kind of come to this board and be hired, personal reasons, because I've had to witness malpractice and be an advocate for friends and family members. For me, that's a huge passion. And so being at the board and seeing how consumer complaints are dealt with, what the process is a huge thing. Because I feel when I didn't know the process, I wasn't able to advocate correctly or know how to do it. So that's a big passion of mine. And I hopefully continue to bring this board more and more comfort with consumers and everyone else who needs to call in and feel like they have someone to advocate. And that is all.
Okay, thank you. Thank you.
Thank you.
For helping us protect the consumer. We appreciate it.
Can add a couple of comments about these individuals sitting up here. Andrea has brought down our consumer complaint initiation tremendously with her addition to the enforcement unit. She does share a position between the admin unit and enforcement, so part-time enforcement and part-time admin. And just to give you an idea, we were at 27 days initiation 2 years ago, and now we're averaging 6 days, and we have stayed under our 10-day mandate. So congratulations to her and to the enforcement unit. And then a visual effect of Jaime and David, they are the two only individuals that do renewals for the entire state. So their workload is tremendous, it's huge, and I couldn't be more proud that they get those applications in and renewed on a timely fashion. You know, we're hopeful that their workload is going to change very soon, and that's one thing to mention about that. And Sanjay is our face of the board. I tell him every day that that smile goes a long way and it reflects over the phone. So great addition to our office.
Thank you.
Question.
Sure.
Are the public able to complain or become anonymous?
Questions directed at me?
Yes.
Yeah, they can. They can call in at any time. The protocol is usually to get them to enforcement as per ensuring that the right protocol go forward and issue the complaint. Usually that's filing online. I give them like a general idea of how to proceed, what's going to happen. My base point with all those calls is like being empathetic and just kind of understanding where they're coming from and making them feel comfortable. Because a lot of times they just want to be heard. So after I get to at least like make some contact and hear what they're saying, hopefully that makes it easier for the enforcement analyst, you know, because a lot of people are going through personal stuff that is very close to their own, the mother, the father, the kids, or whatever. if I don't in some way let them speak and not just come in and we need to do this X, Y, and Z, then they don't feel that comfortable. That's what I want to get first. After that, I'm an expert on the enforcement avenue. So I just direct the person that's going to be able to guide them for whether it's a CSA or a specific analyst that they answer.
Okay, so let me proceed with the report.
Thank you.
We have some new board members, so I went into a little bit of detail. It may be counterintuitive, but the admin services unit includes renewals, which is to probably the public considered licensing, but we have it in the admin services. And so CME questions like before would be directed to the admin services staff and the renewal staff. Also, we do the fictitious name permits and the rulemaking under this particular unit. So it's kind of diverse, more than just licensing. And, but a lot of the action on renewals that we get is in this unit and with Jaime and David. And I put in, and I try not to put words that you may not understand, but SB 806 is the name of a bill that changed the way licensing requirements. So the requirements used to be that people that were applying to get a full license had to complete or demonstrate completion of 36 months of postgraduate training. The legislature changed that in 2022 to require that they can be licensed or eligible for licensure after 12 months. But then at their renewal, they have to demonstrate completion of 36 months. So when I refer to SB 806, that is now something that renewal staff has to verify on the renewal. And so what's a little bit different is that the eligibility and compliance with, does somebody meet the requirements for licensure? That's usually done by initial licensing. But now that they moved the compliance of 36 months of postgraduate training completion to the renewal stage, then that compliance in terms of eligibility is also now shifted. That portion is shifted to renewals, whereas renewals used to just look at CME compliance. So that's what I mean when I say it also includes SB 806. So in moving to the rest of the memo, I have the renewals, if you look at the back page, vary, not the same every month, but nothing in terms of the change is significant. It's just sort of random. And in terms of the performance times, I think that also pretty stable in terms of the quarters. You have July, 24 days, August, 21 days, September, 19 days, and average for 21 days. So that's pretty good performance time frame for the heavy workload that they have for 2 people. For their fictitious name, I mentioned at the last meeting that as a result of going online, it changed our process. We used to, when we received applications in the mail, return them if they were incomplete. And it was a way to only have staff work on completed applications, not have, in terms of performance measures or workload, have anybody that is in our system that is not ultimately completed. The online system, which is we did to be to streamline and to be more efficient, is turning out to be maybe not what we expected in terms of the time frame, because once people apply, they're in our system and they can be incomplete. So now we're not able to return them. We're having to hold them and see whether they cure their deficiencies. So that is taking more time, reflected in the statistics, because before we were processing in under 5 days. And now, as you can see, on the initial fictitious name permits, 57 days, completed permits, 20 days, still not bad, processing time, 42 days. Not that bad compared to what it could be when we were backlogged, but still a change. So we're monitoring what ways that we can streamline, particularly addressing the incompletions. Because when we get completed applications, those are easy and it doesn't take much time to process. It's the back and forth with incomplete applications that's a problem. So we're looking at creating educational tools and tinkering how we can better inform people that are applying so that they can have their applications complete the first time around. I'll entertain any questions.
Board members?
Yeah, Brett Lochner here. So as someone who's licensed long before I came in California, it sounds like what you're saying with licensure is that, and this is through my own application here, the 12 months of completed training, is that basically saying, once they graduate medical school, they gotta have an internship completed before they get licensed? And then that is good for 3 years or so while they're at residency, or what is that?
It's changed. So over the last probably 7 years, the laws changed probably 4 or 5 times. So initially, it was you had to have completed 12 months of residency, and you could apply in your second year of residency and had to obtain the license by the 3rd year of residency. The board had no jurisdiction over those applicants until they were licensed. Then the legislature said, well, you know, we are concerned that for public safety reasons, we probably want to have licensure during the residency. So they created the postgraduate training license. And that license does license them from the start. So as they're coming out, so then they license, then the requirement was 36 months completion, and they had to get a postgraduate training license that would last potentially 36 months. So the license as a postgraduate training license until they completed the 36 months. But then the legislature said, oh, that's causing a problem, so we're going to go back to the 12 months. So after residents complete 12 months of residency training, they can be eligible for a license. But then on their renewal, they have to demonstrate that they have completed 36 months.
Which is when? Their renewal.
Well, for us, it could be their first or second renewal because we had and we're in the process of phasing out this prorated licensure. So when it used to be, we would license someone and then on that day would not be 2 years later. It would be based on their birth date, their birth month. So sometimes a license, but then we made sure that people didn't have licensure for less than 12 months, but more than 24 months. So that process really made us unable to comply with SB 806 because we had people that were coming up based on their natural renewal before they had completed 36 months of training. So then we can't hold their license. So then we had to renew them. But then on their second renewal, and this is what Jaime and David are, track is on their second renewal, they have to demonstrate that they've completed the 36 months. So the other change that makes is that it used to be on the initial licensure that the residency programs just gave us one certification of how much training they completed. Now they do 2. They do the 12 months for the initial license, and then when it comes time for renewal, they have to give us a certification of the 36 months of training that they've completed it. And the reason in the law for the 36 months is there was a belief that 36 months was the minimum required for competency. People were taking the license after 12 months and then going and working in med spas and other things. So it was creating a public safety issue. And this is why the legislature kept retooling, what was going on and tinkering with licensure, jurisdiction and stuff. And so the idea is that they have the jurisdiction and the marketplace, as people that work for hospitals are required anyway to have 36 months of residency. So the 36 months in our licensure law does meet very well with the marketplace requirements and accreditation requirements for completion of a minimum of 36 months. Now, that doesn't apply to specialties, which obviously are longer. The minimum for them is just making sure you complete 36 months and complete your residency as long as it takes to complete. I know it's a lot, and we've been doing a lot of changes as a result of that. So in the end, it was not an easy thing for us to make the change back to the 12 months, because it was easier to say, oh, you are applying for a license. Did you meet all the requirements? Period. And then once you have your license, and all you do is, meet your CME requirement, to now have to split that up into, do you meet initial licensure requirements, one of which is only completing 12 months of residency, and then you wait to demonstrate the other, compliance of the 36 months, now stretches it, at least in our board, across 2 units, and it delays it, and it doubles the amount of certification that's required by residency programs to do. So it's, I think I heard that residency programs did ask for this change. And I think that one of the things that they were trying to fix, quite frankly, is the fact that when the initial licensure required completion of 36 months, and then people needed to get licensed and in a job probably within a day. Like if you graduated June 30th and then you got a job July 1, obviously the board can't realistically process that. Okay. So people were concerned by the fact that 36 months in initial licensure was not working for people. So then the legislature solution was to put it back to 12 months. So all of the time frame of processing, a license would happen during their residency. There would be this big cliff. You could be eligible after 12 months, but now you could stick with, if you don't plan to practice in California, you could stay with a 36-month, now 39-month postgraduate training license and never have to do the full license. So I think we've come to hopefully a place that we're settling into that kind of meets everybody's needs. You're looking at me like, oh my God, that's really hard to comprehend.
Well, multiple scenarios pop up in my head. So for instance, when I was training, some after internship, some residents in the middle of residency decided they wanted to go moonlight doing some pretty light medical work.
Yeah.
So what does that person, was that technically they're a doctor? They graduated medical school, they got through their internship. They could technically salute the world and say, I'm a doctor. And I mean, that's kind of the old school general practice. Most doctors, I think, realized that was not enough. I think more work for some doctors, they would have been like doing whatever, just fill in the blank. And then what about physicians, say, who do their internship and they want to go to sabbatical, or they want to go get Juris Doctorate, or they want to do something else before they go do clinical medicine, but they don't want to forsake their title of physician during that time. What do they do?
That's challenging. I think that the idea was to have in terms of your career, have your minimum 36 months training to make you eligible for licensure. Their applicants are not penalized if they don't apply right away. So if they wanted to go on and do a law degree or another degree, when they decide to apply for a license, if they've already completed it for California, the 36 months, they're really otherwise, if they're otherwise, meet the requirements for licensure, they're eligible.
But what about after 12 months? So they do their internship 12 months after medical school.
Yeah, so so there's 2 things that we've been having to deal with legally that makes that work. The legislature in the particular law, SB 806, did give the board discretion to deal with those kinds of absences and leave taking. And so we have been able to probably resolve all of those types of leave scenarios so that nobody is locked out of a license. It was an issue that we originally brought to the legislature's attention because leave was creating problems, and their response was to give the board discretion to be able to interrupt their training and be able to let them come back in if they are in a residency program. So licensure-wise, it's not a problem for licensure. You know, our goal of the board is not to lock anybody out of eligibility for licensure just because of the choices they make in their career or leave from with family issues.
What about a case where, let's say someone, they completed their internship, or let's say they didn't pass the boards, and now they want to go work to gain more clinical experience in a private clinic somewhere, to gain some apprenticeship knowledge while they're prepping for their next year's boards, because the boards only happen at a certain time, so it's not like they just retake it the next month. What does that person, under what license do they work? They're a doctor, but their 12-month license has expired. They've not completed their 36th month, and they work.
No, not without, so if, that you know, that kind of a decision would have to be where the 36, if they decide they want to not get licensed after 12 months, they could continue with the postgraduate training license that would last for 36 months. If they go the route of the full license and they don't renew it, they're unlicensed. So no, they don't have a legal right to practice anywhere, moonlighting or otherwise. The residency allowance for moonlighting still is under the jurisdiction of the board through their postgraduate training license and if they have a full license. So the minute they don't have a license, they can't even practice medicine within the residency program. And so they would be terminated from the residency program. So we don't have a gap in terms of like people wanting to go out and not complete their full training and still be able to practice. They have to be licensed one way or another in order to practice, even in a residency program or moonlighting.
And I'll add to that, Dr. Lockman, that's actually one of the things that we've been seeing more frequently is that a lot of the residents and their inability to pass the COMLEX level 3, right? Most of the times with the postgraduate training license, they were asking for an extension because it was only good for 12 months. Now with it reverting back to the 36, 39 months, that I'm echoing. So that takes the responsibility off of us to extend that PTO license for them to continue studying or wait for the test. A lot of the times we're finding that they are scheduling their tests, right? I had an applicant who scheduled a test for September, but he would not receive his results until November. There's about a 3-month lag for them to even have their pass-fail score come from NBOME. So during that time frame, they just hold their PTO license until they are eligible to apply for their full unrestricted license, at which point we go through the system and cancel the license once the full unrestricted is issued. Sitting for their boards because their licensure is not contingent upon board certification. We don't worry about that. It's just the COMLEX scores that we look into. And then for the leave of absences taken or research periods, we do have a form online right now to account for that. So if they do leave a program for a research period or they're taking time, leave of absences, we do take that into account. We ask that they provide us with a summary. We kind of cross-check between the applicant as well as their program. And then it just depends on how it was tracked with the program because I believe they have around 3 to 4 week leave timeframe. While in the program, it's just how the program categorizes that leave. If there was no extension added to their residency program or their residency training, that's fine. We don't ding them for that or penalize them for that.
But you're mentioning programs, like accredited programs that get money from Congress to, help train. What about someone who, let's say, has not completed their boards or didn't pass their boards, and so they can't move forward in that regard. But they still want to learn. They still want to, like in maybe, let's say in rural areas or something, where we desperately need help.
Underserved. Mhm.
And what do we call this person? They graduated medical school, they've done their internship, but they haven't completed their residency. They want to effectively apprentice. There's a need, and we see all these other sort of ancillary healthcare licensees who have so much less training and knowledge and skill, who can go out and wave their flag in the air, and yet you've got this fully, or not fully, but at least internship trained physician who's just stuck being told, too bad, so sad, you're not legitimate.
Well, most of the
What can I do if I wanted to train those people? I don't have a residency program. I have a very comprehensive clinic where we do everything from brain injury to toe pain, and they can come train with me. But can they sign a note as, Dr. John Doe? They're not licensed, but they're technically.
They have their PTO license, so generally they don't want to train during that. If they've known they've felt their complex level 3, they're not practicing. They're going, okay, I need to spend this time studying so that I can pass. But they still actively have a PTO license, so it's really up to whatever program they're coming from or would have been completing to either extend the contract to them to.
Or maybe a better scenario would be one of, let's say they don't match. They effectively completed their internship. It wasn't locked into a track route to surgery or what have you. They just did a traditional rotating internship. They're done. They're no longer with that institution, but they didn't match. So they don't have an established residency program into which they're going, and they want to keep their skill set alive. How do they practice? How do they apprentice? How do they keep going?
Not in California, Dr. Lockman. We don't have anything set in place that allows them to have like an exemption for that. I mean, that's something that we can look into the legislator. There are certain things that, an unlicensed, what you would call a physician in this instance, can do under their supervision. We would have to look at a case-by-case basis and what they're doing. So, I mean, there's, nurse practitioners, there's MAs, assistants that can do certain things under physician's guidance, but we'd have to look at it on a case-by-case basis to see if they can still, shadow the physician in certain ways. But in terms of having an exemption or a temporary license, we don't have that right now for this purpose. Like Machiko said, for the most part, I mean, I can tell you that we're not seeing that happen. For this board, we're not seeing, unless we're not hearing that this is happening, but when they're coming to us and we're waiting on that complex, we have seen that third level sometimes where they failed, but the fail rate for the second time is not high at all. They pass it. So they're probably, for the most part, focusing on passing that examination. We're not seeing that much happening here.
I just want to add, there is a word in the law that says that they have to be, one of their license requirements is that they have to train with an accredited training program. So in your example, could they just train with you if you're not part of an accredited training program? The answer is no. Because if they train with you, that training will not be eligible for licensure. So that's the part in the law that is not really obvious, but the word accredited is the thing that is the safeguard and kind of firewall to, can people just, go and practice with a physician and then have that training count? The answer is no. And another version of that is a lot of people are bouncing around out of state, coming in state from different residency programs, and they're running into problems because not all the programs that they want to study within hospitals in particular that have very unique specialties, they're not accredited because it takes a lot of work to become accredited. So the law still requires, as kind of a firewall, is that training must be at accredited program and accredited facility.
Great, thank you. Are there any other board members with questions? Okay. Any members of the public in the room? Any members of the public online?
This is the moderator. We are now open for public comment. Members of the public on WebEx, if you would like to make a comment on this item, you can click the raise hand icon, or if you're an audio only participant, you may raise your hand by pressing *3 on your device. You may also use the Q&A feature down at the bottom right-hand corner of your WebEx screen. All right, it appears there are no requests on WebEx.
Thank you, Ms. Thorpenson, for your report. We are going to move on to agenda item 12, enforcement. Thank you all for coming up and introducing yourselves. Thanks so much for your service. Agenda item 12, enforcement program with Christy, our enforcement analyst, who we just got introduced to.
And if all of enforcement can come up, please. Including Ralph. Ralph, you want to come on up? And then you can just stay for both the enforcement and probation report. You guys can bring up another chair. Yep.
Oh, they're connected. Oh, okay. Okay. We'll start with. Okay.
Good morning. My name is Robin Matson, and I have been with the board just over 6 years in enforcement. And when I first came on board, I was just handling the initial desk investigation. And since Erica has come on, we are now handling our cases from cradle to grave, which I am just very happy about. We get to provide input and knowledge of the case. So yeah, I'm very happy and love the books.
Great, thank you.
I'm Beth. I do the meeting minutes. I also do enforcement. I was brought on 3.5 years ago for the PTL licenses when they first started. So I was going to do enforcement for that license group. And now I do cradle to grave with everybody, and I do all the enforcement cases, not just PTLs.
Okay, thank you.
Hi, folks. How you doing today? Those of you who know me, my name is Ralph Correa. I've been here since January. Been here, 9 months, 10 months, 11 months now. Came from the Med Board 4 years, and prior to that, 20 years as a cop. And I'm head of probation now. Those of you who know me.
Hi, my name is Christy Livramento. I'm an enforcement analyst with OMBC. I've been here just over 2 months and very happy to be here. Thank you.
My name is Steve Lee. I've been here since 2009. Started in social licensing. FFAP work.
Okay, Steve, you're an OG.
One of them.
Thank you all. Hey, Christy, you want to begin your report?
Of course. Like I said, my name is Christy Livramento. I'm an enforcement analyst with OMBC. I have prepared the briefing paper for you for agenda item number 12. You've been provided the stats with your board meeting materials. As previously reported, in July of 2024, the enforcement unit was granted 2 AGA enforcement positions, both of which been filled by enforcement analysts who have carried their own caseload since coming on with the board, who have participated in extensive training, although Erica says not so much, but it has been very helpful. And I know myself have learned a lot since being here. Since the last board meeting, new processes have been established within the unit. One of those processes is the analyst introduction letter. This is a second letter after the acknowledgement letter. This letter is going out for every patient related complaint, and the contact information of the assigned analyst is provided to the patient and or complainant, their phone number, their direct phone number, their email address, and the patient / complainant is reminded that they can provide any information that they want reviewed as part of their complaint at any time to the assigned analyst. They don't have to wait for that analyst to reach out and request information. In addition to that, patients are notified about the impact statement and what they can provide with that impact statement. As a status letter is being mailed out to them, a brochure on how to write an impact statement and what to include is sent to them as well, and they're provided the opportunity to provide their impact statement. Furthermore, the consumer complaint form has been updated to include a spot on the form for the complainant to provide information as to whether or not they've submitted their complaint to any other jurisdiction. That allows the enforcement analyst to reach out to those jurisdictions and request findings and reports from them to review with our review of the enforcement case. As Erica stated, we are working on the consumer complaint tutorial video, which will hopefully be completed later on this year. We also have 2 enforcement brochures, Don't Wait to File a Complaint, and a consumer's guide to the complaint process, both of which have been translated into Spanish and can be found on our board's website. And as you've heard, we have begun conducting the complainant interviews for quality of care cases. That did just begin now in Q2. We have some complainants participating and some deciding not to participate. I have had one complainant indicate that they will be providing additional information for our review, but as of today's date, we haven't received any additional information. Now I will move on towards statistics for performance measure 1. That covers the amount of consumer complaints and arrest and conviction complaints received in comparison to last year. We did experience an increase of 18% in complaints in Q1 of this fiscal year in compared to last fiscal year. However, that increase is only in consumer-related complaints, and the arrest/conviction complaints has remained at the same level. For performance measure 2, that is the number of days it takes our unit to initiate cases and acknowledge receipt. The performance measure for this target is 10 days, and we are under the target of that 10 days. Performance measure 3 is the average number of days it takes to complete an investigation for cases that are not referred to the Attorney General's office for formal discipline. Case aging here fluctuates greatly depending on the complexity of case, the number of parties that need to be contacted to obtain information as part of the enforcement investigation. Enforcement analyst desk investigations, devise investigators investigations. The target date for this is 360 days, and for this in Q1 we were at 165 days, so we're meeting that target. For performance measure 4, that's the average number of days it takes to complete an investigation for cases that are transmitted to the Attorney General's office. Case aging in this category right now is at 902 days. Our target for this is 540. This increase is because of the number of cases that have now been transferred to the AG's office for formal discipline. So they have a larger workload, so therefore it's taking some cases longer to be filed for accusations and then final discipline. We also have less control over this measure as it takes into consideration the timeline, like I said, for the Attorney General's office, the respondents' legal representatives, and then scheduling of hearings with the Office of Administrative Hearings. Currently, we have 409 pending enforcement cases split between the 5 analysts. We have 80 cases being investigated by HQIU and 20 cases at the Attorney General's office. For Q1, the board has filed 1 accusation, issued one citation, and placed 2 licensees on probation. And that concludes my report.
Thank you, Christy. Board members, do you have any comments? No?
Is there beyond targets, is there a mandatory time frame during which some of these post-AG cycle cases must be completed by? 902 days seems like you're looking at 28 months there.
Dr. Lockman, if you look at the statistics chart, it actually has what our performance measure is for each section. So if you want to go down through the list, performance measure 2, which is complaint intake, we talked about the mandate being 10 days. The acknowledgement of the complaint has to occur. And so a complaint needs to be initiated and acknowledged within 10 days. And then our performance measure for investigations, which is desk investigation. So the moment that intake initiates it, Andrea initiates, and then it gets assigned to an analyst up until we close it without discipline, it needs to be done within 360 days. Anything involving discipline should be the target for 540 days. So as you can see, we're meeting essentially every targeted area except for the attorney generals. And the reason behind this is we're still, like I have constantly mentioned, we're still dealing with the backlog of cases. So we have a couple of age cases that we're sitting in these other categories that are now making it to the AG's office, and that's what's skewing that last number. But overall, excuse me, overall, these numbers are going down, and we are, essentially taking a bit more action than before. As you can see, there's a couple of areas here at the bottom of the page that unfortunately the year to date didn't convert to a 0, but you can probably see those here. But you can see that enforcement is taking a little more action than before. And then overall, all of our performance measures are within the statute of what is being required of us, except for the attorney generals. And that's out of our control, as Christy mentioned. And just 1 or 2 really complicated cases can totally skew the number. So we can have one particular case that's dealing with 10 patients per se, and that overall number is going to be accounted in our total number, which will then skew the numbers drastically.
Sure, I'm not being critical of the board here, and all the numbers look good. I'm looking specifically at that time with the AG. Is there a time frame after which enforcement is jeopardized because it was hanging out with the attorney general for too long?
Well, the board would be required to file the accusation by the statute of limitations date, but past that date, there's all the outside factors that's communicating with respondent and their attorney, and also scheduling with the Office of Administrative Hearings. Sometimes we can't get calendared for a hearing for over a year, and that's completely out of our control.
Sure, I understand that. At some point, can a physician who's been complained against say, hello, it's been 4 years. Where's my right to a speedy trial, so to speak?
They can have that discussion with their legal counsel, can have that discussion with our legal counsel, which is our attorney general. But essentially, all the healing, our boards are going to the same unit within the department. And, those are factors that are unfortunately out of our hands. Like Christy said, our mandate is just to file that accusation and get that filed so that we can meet the statute. After that, we try to work with the attorney generals to try to negotiate stipulations before we even go to court in those cases that we truly, can stipulate. The ones where there's a severe patient harm and we want full revocation, we're going to end up going to court on those. So again, it's out of our hands. The only thing that, and you mentioned, does the board get penalized? The penalization here is consumer protection. We're not meeting we're trying to meet the consumer protection aspect, but in some instances, the process is to, wait and go through the whole process.
I don't mean the board get penalized. I'm just saying, is there a line in the sand after which someone goes scot-free because the AG's office didn't penalize before that line in the sand? That's my only question. Not so much, did we do our job? Just once it lands in the AG's lap, is there a point after where someone can say, like, basically statute of limitations for acting, not for filing the complaint, but for acting is up?
Once that accusation is filed, no. Yeah, once that accusation is filed, no. And on the board side, our goal is to get that case transmitted with a 6-month cushion for the attorney generals. But I can tell you that if we have expedited cases, which we have gone to, like, let's say a week before the statute, and we have everything that we need. The AG's office has worked with us to get that accusation filed overnight. So that's one of the things that with enforcement, luckily for us here, we haven't had much of an issue that way. But in the past, when I first joined, we had a few cases where we were, filing accusations within a week after the investigation was completed. We're not seeing that so much now.
And then also, if I might add, in cases where there's a suspension or an ISO, then those cases are scheduled for hearing, I believe, within 30 days of filing the accusation, which is about 2 weeks after the ISO hearing. So in those cases where they're restricted from practice, then they do have more of a speedy trial per se.
Any other members have questions? Any members in the public that are in the room? Any members of the public online?
This is the moderator. We are open for public comment on WebEx. If you'd like to make a comment, you may raise your hand and or use the Q&A feature. If you're an audio-only participant, you can press *3 on your device to raise your hand. And it looks like we do have a request for public comment. Michelle Montserrat Ramos, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device. All right, Michelle, and you are unmuted.
I am Michelle Montserrat Ramos, and I'm with Consumer Watchdog. We are happy to hear that your executive director swiftly hired the 2 new analyst positions, which became available to you through SB 815. Because she took action so quickly, this board was able to begin conducting interviews for complainants before the consumer complaints were closed. This is a key consumer protection that both boards should be conducting now, but only your board is doing today. The changes to the analyst introduction letters are important. It would be helpful that the letter notifying the complainant that their complaint has been referred to a field office includes a name and contact of the investigator assigned to the complaint. It would help the complainant to have this information so they know where to send any additional information they may have to support their complaint. We appreciate the changes to consumer complaint form in order to give consumers the opportunity to notify the board that they have filed other complaints and give board staff an opportunity to request the findings from the other entity. That takes the pressure off of the consumer to figure out where their complaint is and how to forward the information to that entity of the enforcement process. And it helps provide staff more information, which will save them time and make the process more effective. In many cases, the CDPH is not addressing the consumer's complaint to them, and it's just referring their complaint to your board. With your staff aware that a complaint is filed, they'll open communication and should again save your time, staff, and increase effectiveness. We appreciate the board taking the action to translate 2 of the enforcement brochures into Spanish. We have quite a few new families that have joined our team that are monolingual Spanish speakers. This will assist them as they will all file complaints in the near future. We have come across an issue with the NBC in terms of their ability to communicate with Spanish-speaking Californians in person and at their public meeting and via WebEx. We appreciate that this may become an issue with this board in the future. This is something that we will need to discuss as some of these families are actively pursuing accountability for their families. Thank you.
All right, this is the moderator. It appears there are no further requests on WebEx.
Thank you for your comments. And thank you, Christy and team.
Thank you.
For introducing yourselves so that we know who you are and what you do. We really appreciate what you're doing for this board. Thank you.
Thank you.
Okay, we are moving to agenda item 13, presentation on the board's probation program presented by Ralph Correa, our probation monitor. Ralph, take it away.
All right, good afternoon, folks. Good party started here. All right, to let you know, the probationary discipline and probationary summaries are regularly updated in the website. That's usually done by the director herself. Her and I get together, we talk regularly, and it's usually done within the first 8, maybe 24 hours. So anytime somebody needs to look up a physician to find out what their status is, it will be there, okay? As of today's date, I have approximately 32 licensees on active probation. 6 of those are actually out of state. And because they're out of state, they're not receiving any credit towards their probation. They still have a license in California. They're just not completing anything because they're just not practicing here. So they're not receiving any credit. Their time will be considered what we call hold time. So every date that they're not here, it just keeps getting extended until they decide to either come back to California or petition or do whatever it is that they're going to do. Okay. As far as reviewing the cases, I do quarterly reviews with each and every one of my probationers. That means I actually have a sit down, either it's face-to-face, Zoom, or I can do it on the phone, dependent on their actions and their compliance. All information is documented. I receive all information regarding their compliance. I review it, I analyze it, I make phone calls to make sure that it's accurate. And then I go ahead and document it in an actual report itself. As a result, the statistics show that 32, so I have 32 total, 26 do remain compliant as of the third quarter. This does exclude the 6 that are still tolling. And I do maintain an effective and thorough accountability of all my physicians on probation. As far as the non-compliance goes, so back in July of this year, 1 physician was issued a cease practice order. As of the end of the end of October, this physician did complete a course that was mandated by that physician, and they did meet the qualifications and are now back in compliance and now have been released to practice medicine. So they were put on a cease practice order for approximately 3+ months, and now they completed the course. They can now practice medicine again. I will let you know that I did actually go down to that physician's practice location to make sure, in fact, that that person was not practicing medicine. So I do hold every physician accountable for those specific actions. When I tell them that they cannot practice medicine, they need to be aware that they cannot practice medicine. And I ensured that by letting their staff know to find out if that physician was there. And they took me to their office and told me, no, take a look around. The physician is not here. And of course, naturally, the physician called me the next day and wanted to know, hey, you stopped by my office. And I said, yes, I did. And they said, well, I'm not even here in California. Good. Don't practice medicine until I tell you. So with that in mind, obviously the doctor was allowed to practice medicine as of the end, towards the end of October. Then on October 30th, I received another report from another organization that another physician was not in compliance. So I now have another physician that I just issued a cease practice order on. The director and I have had, we went over direction on how to facilitate this. And for this specific one, we're discussing future discipline for this specific physician. But until then, this physician will remain on a cease practice order until the Justice Department and the director and I facilitate to figure out what that future discipline is going to be. Okay. And also, I will be stopping by that physician's location to make sure that physician is not practicing medicine. So rest assured that I will be doing my job. As far as the diversion program goes, out of my full 32 probationers, 4 of the probationers are participating in the what we call the diversion program. I oversee that. And I maintain my stability with that specific organization, including the physicians themselves. As the director has mentioned in the last board meeting, and obviously just recently, Maximus is no longer going to be having a contract with us. Those specific physicians will be coming directly under my watch. I've always had it since I got here, but now they will be just formally having to answer just to me and me only. The new diversion program will come in line sometime after December, top of January, and we'll discuss with them and what we're going to be working on. But for the future, all probationers that will have some type of drug or alcohol problem, they will not be going to a diversion program. They will be coming directly under my watch. And so because my unit will have our own biological fluid testing, I will be dealing with that organization to make sure that those physicians, whoever has those specific problems, will be monitored when they have to test and going over that information with them. Okay. Other than that, it is right now it seems to be a pretty smooth transition. We don't foresee any major hiccups. That's pretty much all I have for you guys. You guys got any questions or concerns?
So I have a question. How long were we with Maximus, or they with us? How long?
Sorry,
How
really?
long was Maximus with the board?
Oh, boy. Director.
I can help with that. A very long time, probably dating back to 2001, at least I can say. As you probably don't know this, but my first job that I worked directly with the state, with DCA, was at Maximus. I was a compliance monitor for 3 years, and that kind of landed me to venture over to this world on this side. And so in 2001, I was a compliance monitor, and they had been already in operations probably 3 years prior to me joining them. So we're looking at over 20 plus years that we have held the contract with them. So this came of a huge surprise to all of us, a huge stressor. We didn't expect that. But one of the things that we have learned is the population in general has been decreasing, and that was one of the reasons why they made the decision possibly to pull out of the contract. They weren't getting as much participants and not getting as much funds. And they're a huge organization. They handle all kinds of different government programs. And so, that could be the reason that, for their reasons for pulling out of the bid. But the one that is the most effective of all of the healing R boards is BRN. They have over 200 participants, like Ralph mentioned. There's only 4 of us, 4 licensees that are part of probation that participate in the program, and the rest are self-referrals, with the potential of becoming board referrals, because a lot of them that we're noticing do enter on a self-referral basis because they either know that an 805 has been filed, or they themselves, would like to be proactive and get help. Ralph is going to, continue the monitoring of these folks. The self-referrals, we're just going to let the new vendor handle them as they are, but Ralph will be more involved with those probationers. One of the things that I had mentioned in the prior meeting of some of the things that we were noticing with Maximus and a couple of hiccups was that it makes it really hard when 2 separate entities are essentially monitoring the compliance of a licensee. And for this board, what we learned, Ralph and I, was that they established a greater relationship with Maximus than the probation unit. And so now we're trying to educate our licensee that ultimately the only one that could revoke your license is not Maximus, it is the board. And your relationship, your number one priority should be with your probation monitor, with also, the oversight of the diversion program. So those are a couple of things that have risen in the last couple of months that we're working towards, and establishing, hopefully with our new vendor as well, to make things smooth.
Yes.
One thing I also noticed regarding the Maximus program, and I agree a lot with what the director said. But one thing that I did notice was the diversion program was essentially telling a physician that for whatever reason they found they can't practice medicine. And then they would tell the doctor, go home for the day or go home for the week or go home for the month or however long they deemed necessary. But there was no documentation from the board regulatory agency that facilitated this action, in which case it should have been put out for the general public so the patients or the public would know what physician was actually not allowed to practice medicine. There was a lot of break in communication as far as what that diversion program was probably supposed to do versus what the prior administration was actually doing during that 30-year tenure while Maximus was here. So of course, naturally, when I came into play, I started hearing and actually talking to my physicians going, hey, what happened with this specific time in your life? What were you doing? Oh, I was told by Maximus that I couldn't practice medicine. Well, who authorized that? And their response was, well, Maximus. Well, did anybody from probation contact you? And their response to me was no. And then, of course, I would actually talk to somebody, Maximus, and I actually asked him, who authorized you to tell a physician they couldn't practice medicine? Well, that's what we always do. Okay. So naturally, the director and I, we put our heads together and we put a stop to that. Since we're the regulatory agency holding that license, we actually made this legal. So this way the general public can find out, in fact, what doctor is allowed to practice medicine and what doctor is not allowed to practice medicine. So for me, I take it as a blessing as far as, them moving on with their organization, and we can keep a hold of that and make it totally legal. So the general public can see this, since the fact that we do work for the public.
One of the effects of that Ralph just mentioned of the non-practice, some of our physicians have a specific, you call it a clause in their decision and order that they are to be practicing. And so the non-practice of Maximus was suspending them from practice, and we didn't know of that suspension. We weren't tolling their probation like we were supposed to. And so that's kind of like a real effect of these issues. The other component is, lifting requirements of health support group and that being part of the probation contract. We can't do that without having your vote as a board. Petition for modification of their probationary terms would have to formally be submitted and brought to your attention so that you all can vote on that. Ralph and I can't make that decision. We can recommend, by saying this person has been in compliance, unless it specifically says that a board representative or a board designee could make that decision, but it has to be written that way. Most of the disciplinary documents that were written in the past don't have that language. So they would have to file a petition for modification of probation or early termination of certain things. And those things were not being done.
Do you have any board members? Yes.
Just a comment. I just wanted to thank you for your hard work, protecting the public.
I always like hearing you talk. You sound like you're on a tight ship. What I don't know though is the six actors who are on probation but non-compliant because they're not in the state of California. And I presume they have not communicated with us about, what their plan is to complete that. At what point can the board take unilateral action on that license and say, well, if you don't have any intent and you're not communicating, you're done? Like do we have a process for that?
Okay, so yes. The older decisions didn't, when Justice Department and this prior administrative board decided to write down the decisions, they didn't actually enter specific language in those set decisions. Because of that, I will be forced to literally babysit those cases on my desk for eternity until those doctors either decide to come back. The director and I are looking at other avenues to try to figure out what we could do to minimize some of those cases, whether it's either take further action. Now, I'll try to make this short. Most of those physicians got action from California because their home state, they actually got in trouble in their home state. And because of that, we took action because they decided to hold a license here. Now, if that physician completed all their requirements in their home state, there's nothing that would preclude us to say, well, if you completed everything that was required in your home state, even though we took action, can we determine that that would suffice the same action of what you would be done in your home state? Now, can we do the same thing? So if they cleaned up their act over there in their home state, can we close their case here? That's something the director are actually looking at, whether we can close the case, but on the contingency, in fact, that they actually did all the requirements and completed the probation in their home state. Now, I have had that done already. In fact, contacting, whether it's New York or Arizona, contacted those specific states because I have a mirror. I talk to my mirror and talk to their supervisor, and they would go ahead and provide me with an actual document, say, hey, Dr. Smith, whatever, completed all the probation requirements. They're on probation for 3, 4, 5, 6 years, and they completed it back in 2018. They've been closed. We don't have anything else. Meanwhile, I'm sitting on a case that's collecting dust. Can we, in fact, clean that up? So we've gone back and forth to try to figure out, we don't want to blur the lines. We want to make sure, in fact, if a doctor wants to come back to California to practice medicine, they're clear and free. But as far as further disciplinary action goes, we're having a hard time trying to figure out if we can push them off over that ledge and going, hey, you can't practice medicine here at all because of the way the regulations are put. And of course, naturally, the way the documentation is written down on the decision. Does that answer part of your question? Okay. Now let me reassure you with something else. The way the new decisions are written today, the director and I have put our heads together and we have created the new decisions to write down if in fact a doctor is not practicing medicine more than 2 years, then it's automatic petition for revocation of that physician's license. So this way I don't have to have cases on my desk sitting there for 8, 10, 15. I actually have one that's sitting on my desk that's 21 years old. So you could see I don't want to have a case on my desk that's 21 years old. If you're not practicing medicine in California and it's gone over 2 years, we're not going to keep your license. You can go practice at your home state, or not practice at all. And we're not going to do that in California. So we've changed the way the decisions are written today.
Dr. Soin, and this is a consequence of having really outdated disciplinary guidelines. So let's start with saying that our guidelines have not been revised since 1962. In January, you all are going to be presented with proposed disciplinary guideline language. That's taken us 2 years to draft for you. That was one of the first things that I noticed coming in. Right away. I'm like, where's my guidebook? You don't have a really good guidebook. And so that's been our project. This is why we have an RA, Becky, who was the executive director of the the Physical Therapy Board of California for many years. I just go on autopilot. And she's been helping me draft those. She did physical therapies a while ago, and she's been a blessing and proposing, that we redo all of this. And it's going to turn into a 100+ page document for you all to review because that's how outdated they are. But in stipulations, I have the ability to stipulate terms and conditions. So in proposed decisions, the ALJ goes with our guidelines, which is what's been formally adopted by the board. In stipulations, I have a little bit of a discretion, and we've been, Ralph and I, coming up with these new terms and utilizing medical boards as a platform and as an example, and putting those things in there, including probation monitoring fees. We never had collected probation monitoring fees. And Ralph costs the board money to travel, to go do inspections. And so those are things that we're putting into play. But this ultimately, the 6 tolling individuals should have never happened. And now with the language, we're hoping that it doesn't happen. And one other thing that I like to mention is that we did offer surrenders to them. Our licensees don't want to surrender their license. They want to keep their license. And so even though they have no intentions of coming back to California, you know, they're very prideful of their profession, like they should be, and they don't want to give up their license that easily. So they're essentially stuck in limbo. And like Ralph said, we're looking at them at a case-by-case basis. That is a project that he and I are doing to see if there's anything in their language that allows us to take that discretion.
Thank you. Any other board members? Any members of the public in the room? Any members of the public online wanting to comment?
This is the moderator. We are now open for public comment on WebEx. If members of the public online would like to make a comment, they can raise their hand or use the Q&A feature down at the bottom right-hand corner of their WebEx screen. All right, it appears there are no requests on WebEx.
Okay, great. Thank you, Ralph. We are going to break right now for lunch. We are going to break for an hour and 20 minutes. So we're going to return back here at 2 p.m. Thank you. Great. We are returning back. Are we all set? Okay, we are returning back to the board meeting. And I want to welcome everyone back, and we are going to start with agenda item number 14, discussion and possible action on legislation. Ms. Terry Thorfinson is returning back to report on the, before we get started on the discussion around the bills that she will present to us, we need to do a roll call.
Corey Damian.
Present.
John Cummins.
Present.
Dr. Lockman.
Present.
Andrew Marino.
Present.
Dr. Patel.
Present.
Denise Pines.
Present.
Dr. Swain.
Present.
Quorum has been established.
Great.
Okay. Madam President, board members, I want to just, as I always try to do, go over my little overview of where to look for things, because you may be looking while I'm talking. In the online version, each of the bills has a hyperlink that if you click on it, it'll go right to the bill if you actually want to look at the bill's language beyond what I've described. The first section is talking about which bills got captured and which didn't. These are our list. The universe is our list. So as you can see, the first bill, the Skinner bill, that was about a temporary licensure for Arizona physicians and patients to perform abortions. It will be sunsetted and end by the end of December. And so that one is coming to a close. The next one, we took a position on the SB 1451, the title protection. That bill did achieve some title protection, not the kind that we wanted, but worth mentioning. It added the word doctor of osteopathy to this title in the statute, because it used to be MDs, DOs, and there's no definition of DO. So that's the gain in that bill for us on the title protection. We were looking for trying to have osteopath as a title also protected, and we did not, I think I told you at the August meeting, did not succeed. This bill is a committee bill, so we knew that it would be signed into law, no surprise, just doesn't have exactly the type of language that we wanted on osteopath. I think as we've mentioned, OPSC is planning on doing a bill next year that would address the title protection for the word osteopath. AB 2164. Huh?
May I ask a question?
Sure.
Although I'm happy with that, really it should be osteopathic physician or doctor of osteopathic medicine. The term osteopath, osteopathic doctor, it's kind of 1950, 1960.
Yes.
How they came up with that. It's better than what they had, but it's still kind of like,
well,
defined as a
Well, what's being, where the issue came up in a bill 2 years ago is they took a AMA, American Medical Association list of titles that they wanted to be used in all states to clarify what is a doctor, And on that list, osteopath was included with all the various osteopathic terms. And it got removed from the list in the bill that eventually died. And then the subsequent bill, which is this bill, in the same 2-year session, did not add osteopath back in for protection because the chair of the committee wanted to allow it to be used by non-licensed osteopaths. So the non-licensed, so yes, it is an old term. People prefer licensed physician and surgeon, for example. But it is, to cede it to unlicensed practitioners would not only confuse consumers, but pose a lot of risk for people that are claiming to be trained in osteopathic medicine that has no relationship to what osteopaths and osteopathic physicians are trained in this country only. So we felt, we took a position on it. We felt that it was strong enough, and OPSC also feels strongly about it. It needs to be a protected title because it could be rampantly abused and misused by people that are not otherwise licensed, but claim to consumers to be not only osteopathic trained in their country, which varies a lot, but also probably using osteopathic manipulation treatment, which by statute is limited to only licensed physicians. So a lot of public risk for, public safety risk for consumers, a lot of a room for a lot of confusion and misrepresentation of titles. So that remains an issue, kind of unsatisfying, but.
Is there room to further narrow or further expand it, should I say?
Further expand what?
Title protection for doctor of osteopathic medicine, beyond just, I'm not sure it's written here, but.
Yeah, click on the bill and see what language
Oh, there.
they have in there.
Dr. Lockman, and like Terry said, the OPSC is going to be working on that, which I'm assuming at that time, they're going to come up with language, not just for the word osteopath, but to include more of a title protection. I mean, that's the intent of what they're going to be working on legislative wise. Yeah. And we'll have, we are working with them in partnership to review that proposed language.
Yeah, so we kind of, because the bill came up, we both took the lead on opposing it unless it had, that terminology. And so we are also continuing to work with OPSC in their taking the lead to bring legislation. Bringing legislation other than what we have when we do it in committees is really not the role of government boards. Like if you're a private organization, like OPSC, that's more of their role, a membership organization to bring legislation. So they're the group to be taking the lead, I think, so far on this. We worked together thus far in the bills that we had and didn't quite make what we wanted. So the next bill, we also took a position on AB 2164. This bill was brought because there was concern over the way the medical board asked the question related to impairment. And we had been in a flux with all of our changes to online licensing and stuff. We had already heard, the concerns, and Machiko and Erica looked around and looked for better language. So by the time this bill came out, we were actually compliant with what it was. So the bill was really directing, although it was directing both boards, it was aimed at having the medical board change their language. But it did include language that didn't apply to us. And my concern was to just make a technical change so it's accurate, and they did not. So we can live with it. We're compliant, but that bill also got signed into law. And then the rest of the bills here on this list are on our watch list. So that means we didn't take a position. but still worthy. One of the significances of watch bills is that a lot of times if the board may not feel compelled to take a position, but it will affect physicians. So one of the reasons that I keep a watch list is because this then goes on our policy alerts to explain, so what did the legislature do that would affect physicians? So there is really, and to me, that educational value in keeping track of what affects physicians is important. And so that is how I make my watch list. And that is usually a bigger list than the position list. So I wanted to, before I go to the memo, I wanted to just give you a glance. If you look at the page 1 and 2, the first pages all have, except where it says NA, has chaptered and effective dates. So that means that they got signed into law. So roughly a little bit more than 50% of this list was signed into law at a glance. The second page has the ones that were not, pretty much, with some exception, were not signed into law. So if you wonder, like, how many bills of the thousands, maybe 4,000 some odd bills that are introduced, how many get actually signed into law? Sometimes it can be very restrictive, but I want to show you a couple of things at a glance on this list. CME, all the CME bills that got introduced, that would be starting with AB 2270, menopause, mental health, physician health care. AB 2581, maternal mental health. AB 3119, long COVID. SB 639, special needs of dementia patient care. Those all got signed into law. So so the legislature likes adding CME topics. So every year we always get more CME topics. Among the things that affect us in terms of the board, given that you just voted on our CME reg package, is we had to make sure that all of the bills that became effective in January were taken into consideration, included in our reg package, which they were. So we're covered, at least for this year, on the mandatory CME. But a lot of these are discretionary, so that will not affect going forward our, needing to change regs necessarily. But it's a subject that's popular with legislators to add topics. I think from the position through the years that I've observed, I think I mentioned that I felt like the board, from a policy perspective, maybe wasn't in such a good position in their regulatory role to pick and choose which CME topics they liked, even though we might like some more than others. And so we didn't take positions on any of these CMEs, not because we couldn't, but just as a policy. If we don't, you run into potential political wins if you decide, okay, we're going to like, let's say, the maternal health, but we don't care about long COVID, then everybody goes, well, how come you don't care about long COVID? That's an important issue. So that's something to think about. It's a bias. Any of you can override that by saying, when we vote on bills in the spring, oh, I want this bill to be a board, position. So I just wanted to highlight those all got in. The other category here is expedites. That was kind of a theme this year, a lot of expedites, and they did not get signed into law. If you notice, the first one is the AB 2862, Gibson, to expedite licensure for African-American applicants that can, I think the language was to show that they were descendants of slaves. And the expedite for gender affirming was vetoed. And let's see, where was the other one? I thought there was a second one. So in the governor's veto message, he specifically heard what our board and other boards were signaling, which was one, on the 2862, we had more concerns about documentation. But we also have the concerns that if you keep adding the legislature to expedite categories, pretty much it dilutes the whole idea of expedite, that is supposed to be smaller, targeted kind of expediting of applications. And the legislature and their analysis reflected that, as did the governor's veto of these. He reflected the concern that maybe we have enough expedites and that we need to, as the legislature, need to relook at those because some of those expire, I think, in 2028 or 29. So that's a theme on the expedite. And expedites influence our board more because that's daily operations. We have to do changes. And mostly Machko has to make those changes very rapidly, and Breeze and all of our daily operations. So it's no small thing. Where CME, not so much. So those are the biggies at a glance. So let's go to the second memo where I explain bills. And I want to highlight not all of them, but just some of them, a couple of them. And I want to start with, since I've already gone over the position bills, I want to start with on page 3, AB 1991. This is what they call the HCI survey, Healing Arts Workforce Data. And this bill looked like it was going to make changes to the current physician survey as well as Healing Arts survey. But in the end, what was negotiated and found out, the intention behind the bill is legislators wanted the National Provider Identification Number of physicians to be added to the survey as a requirement. So that will impact you all. The law says that if you have a National Provider Identification Number, you would, when you renew and have to fill out that physician survey, there'll be a question added that says, please fill in your, if you do you have a national provider information survey, identifier, if so, yes or no, and then probably you'll have to fill it in. So that's new. And the reason for that, the legislature felt like it would be helpful for workforce data. And physicians, as you may or may not know, don't really have workforce data anywhere. And the federal Office of Workforce that compiles different professional data. Usually it's funded, it's expensive. We don't have specific funding, so we don't have it. So it's been a kind of default beefing up this physician survey as a way to try to figure out what's going on with physicians. But I guess what I understand why this national provider identifier would be helpful is it would give them an idea, I guess, through the years of maybe how many people are new and leaving the profession. So it'd be like, and not everybody has it, so it's not going to be not going to completely capture a workforce question, but it is workforce is what they're after with that information. For that, it'll have to be implementation wise. The Med Board takes the lead on the physician survey. They house the software for it. They do it on our behalf, and so they will be taking the lead on adding the questions that will be necessary to achieve getting that. Now, they claim also, not to be punitive, is that if people don't answer the question, that won't be a prevention of renewal. So that's important. That was one of the things that the boards asked, clarification. And the dicey part about effectiveness of workforce data, if you don't require it, it really renders the actual quality of the data much less in terms of conclusions that can be made. But people don't like the idea of being required to give up all this information. So that's always the struggle, and that's why we don't really have good workforce data. We don't have special funding for it either. That's another reason. So this is an attempt to gather that workforce. Again, we didn't take a position on it, but it's important for you to know. You'll probably see it. I don't know when and how soon it'll be implemented in the renewal surveys, but that's where it's going to live, is when you renew and you do the physician survey. Any questions on that particular bill? Okay.
The other one I wanted to go over is SB 639 on page 9, adding special needs of dementia patient care to required CME. This, other than the other kinds of CME that was added this year, this is in what we would call a mandatory CME section. And what page? Oh, the bill is SB 639 on page 6 of my memo. Yeah. So that the section that it was added to already requires that physicians that have 25% of their patient population that are over 65, that they need to have training, a percentage of their training every renewal in geriatric and kind of elder care. This is adding to that. So another topic area to meet the percentage of what they would, 20% of mandatory continuing education if you meet that, level of your patients are at least 25% of the patients that you see are 65 years and older. So it's not just adding a CME topic, it's adding a CME topic to a mandatory CME for those that have that patient population. So obviously if you don't, it doesn't apply to you. So in that sense, it's not mandatory for those that don't have that, meet their criteria for that patient population. Okay, on page 7, AB 3030, which is the AI bill that we discussed. That bill, if you recall, tries to provide some beginning regulation and oversight of the use of AI in the healthcare field, and it basically kind of compromised some of the concerns people had. The concerns being the hospitals worried about the punishment and, and so they got exempted from that. And then the other concern was accuracy. And so the compromise, somewhat addressing the accuracy of the AI, particularly as it's used in medical records, was that if used, the physician would have to disclose to each of their patients that they used AI, and then they could just use it and hope for the best, or they could be exempted from the bill by just saying, I'm not using AI, I'm reviewing whatever the recording is. If I partially use it or I don't use it at all, I write up my own notes, and then this wouldn't necessarily apply. It doesn't address a lot of the concerns that are still out there with AI. And I know some of the board members expressed a desire to have AI and that it was a pretty widespread. And between August and this meeting, I got a notice from my healthcare provider about AI saying that they did a little bit of a modification. It wasn't just at the time I have contact with them. It was saying, we're going to use AI and you can tell your physician or whoever you meet with that you want to opt out of the use of AI. So that's how they're implementing that notice to consumers. So it's a kind of a minimal bill. And then the other thing is they originally did not want to have any kind of punitive effect to this bill. But in the end, the language gave osteopath and medical board the discretion to deal with complaints related to AI as they choose. Now that's pretty broad. And so that'll be yet to be determined, about how that works. But discretion is kind of discretion. And you're part of that discretion in terms of cases. Yes. Do we have a what? No, we didn't have a position on this bill. We watched it. I was concerned if we had had a position. The reason I did not put a position on is I didn't myself, as your policy person, know enough about AI. As it turns out, as I watched the bill very closely, I think I was glad we didn't have a position because there were a lot of really good opposition concern analysis that I was just totally unaware of. Accuracy in medical records was one. The hallucinations that these software programs can produce uncontrollably, so quality control was a concern. The confidentiality, when you put input into software, where does that go? What's the firewall? Like, where does that software live? And i.e. the information, and all the information in healthcare would have been confidential. So a lot of those things were concerns raised in the process, and that were raised like June, July, when I would have been able, I just keep track of the bills and see the analysis. So I was more informed by our August meeting to be sort of relieved we didn't take a position, because it's really important you don't weigh in on a bill that you later regret because the details come out. And this one is one of those. It's fast moving. I think we'll have another opportunity potentially in the future, because AI is expanding so fast and many of the concerns are not completely addressed. So just because we missed this one doesn't mean that we won't have another opportunity.
Do we have to take positions, or we could just stand by and watch some?
We can stand by and watch. So, and I always want to emphasize, when I put together a list and make recommendations to take positions, I'm thoughtful about what the subject is that the board, it would be an appropriate role for the board to take a position. And whether we would be getting in over our head politically, for example, for any reason, or whether we just don't know enough about the bill. Like that was true with this AI bill, very much in our ballpark, but we just, I just didn't know enough about it to present to you to make a rational decision on whether we should take a position for or against.
Thank you.
Mm-hmm. And so I think this one, the governor wanted this position, so this bill, so I didn't have any doubt it was going to be signed into law. It was kind of fast and simple. It created one layer, but definitely, with the amount of money that's being put into AI, the fast, rampant expansion of its use, not all use would be necessarily good, and there is no quality control or confidentiality controls to this. And so that's a gaping hole. And, as an attorney, I see what the legal profession is recommending, and they're warning attorneys putting confidential information into that software to say, you don't know where that goes. And if you have a really controversial client and it gets, hacked or something, and now you're out there, you can't undo it. And so they were warning very, very seriously about the use of it in the legal profession. Now, I know it's being used from anywhere from imaging to now maybe medical record notes. Medical record notes was specifically cited in the ledge analysis by the Nursing Association that said they did a study and they found 38% error rate on medical records. So, that's still out there. But we have some kind of framework, and the board may or may see cases about this. Any other questions on this bill? Okay, and another bill that we didn't necessarily take a position on, but it'll affect your practice, is that on page 7, SB 607, controlled substances and patient education, adults and children, related to, and this is kind of a bill that is trying to address the opioid crisis. And so part of the crisis can be controlling the actual substance. Some of it could be controlling it in cures, and another part is education. And this bill is trying to say, physicians need to, if they're putting their patients, either children or adults, on opioids, there needs to be an education component to their visit that warns of the risks of overdose. So this was originally for children only, and they just thought, why limit it to children? Why not just have it be both adults and children? So that bill got expanded and kind of wide support. Okay, turning to page 8. SB 636, Workers' Compensation Utilization Review. We also did not take a position on this. I recommended not taking a position because one, we were late to the game on this one, a year late. And the other thing was that this is a very contentious political battle. Workers' comp is one of, like scope of practice, one of the most contentious legislative issues in the legislature. And they always have a couple of versions of very tense fights where professions really, fight each other. So the issue, though, would have been in our ballpark, which was that the unions, which were going against the health plans, were saying that if you have patients that you serve in California and you use utilization reviewers, that they need to be licensed in California. That was the main issue. So that sounds like a great issue for our board. The reality was that they lost. This bill was vetoed. The politics were against it. And so the governor was not willing to make that requirement. And the reason was, the rationale for not having physicians licensed was that it's cheaper and easier to find utilization reviewers across states to effectively, in a very efficient time manner, review these claims. And if you require, this is the argument from the health plans, if you require that the reviewers have to be licensed in California, you shrink the number of reviewers available to a health plan that operates in multiple states. And they said that they didn't think that there was any difference in quality. So that, because of the bigness of the players, health plans, a lot of money, unions, somewhat money, that battle may be refought again. And if we're in on the beginning, we can reconsider something like that, because it seems like there's a gap, in terms of workers' comp now, if you're having other than licensed physicians weighing in on decisions, utilization review decisions. And those are the ones I wanted to highlight. Is there anybody that wants me to talk about any of the other bills that either didn't make it or made it? Sure. Who will be doing the review? Good question. That's kind of hidden. That was one of the things that they did, because the workers' comp allows the medical, what is the terminology? The medical reviewer. You can be a more than a physician, and you can be a medical reviewer under workers' comp only. So like acupuncturists are considered physicians under workers' comp. Chiropractors, also physicians under workers' comp. I don't know what mid-levels are included in that review.
DPTs, doctors of physical therapy, are considered.
Are they, they're considered, yeah, so they're considered eligible to be like the medical reviewer, which I think originally you thought of as a doctor role, but it has under workers' comp, which is in the 90s, added who would be involved in that medical review.
Maybe this is completely outside the scope of this, but how does workers' comp in California, how are they so very often have complete decision-making authority about when someone has met maximum medical improvement and whatnot. How does that not violate California's corporate practice of medicine? You basically have corporation hiring providers, whatever that means, to make final decisions about what is allowed and not allowed beyond just what they're going to pay for. But they'll literally say, we won't, we're not going to go forward with this. How does that not also at the same time violate the corporate practice of medicine, which was exactly that when the railroads were being built way back in the day, and they didn't want railroad companies' doctor or the railroad company to own the doctor's decision-making capacity.
Right, right. I think two things. Workers' comp is a separate kind of framework in healthcare. It's got its own statute. It's got its own standards. Similar to like the prison system's healthcare also has its own statute and own standards. And so it isn't the same as like the rest of healthcare. That's one thing. And two, when it was created through the years, it went through a large evolution to go beyond doctors. And when it did that, I think it might have, not that corporate practice of medicine couldn't be violated and you couldn't bring a case. It just, nobody's brought a case, I guess.
Dr. Lockman, the other component is that your reviewers are not rendering actual patient services. They're not treating the patient. So that might be another component there. They're providing an expert opinion on evaluation of medical records. So it's dependent upon, whether they're actually, I think the differentiation would be if they're just evaluating records versus actually providing treatment and care to that patient.
Sure, but I've seen some of these doctors who will deny care to my patient, saying that there is no evidence to support it, yet they themselves in their day job as a physician provide the exact same care that they're saying for which there's no proof. So they can't have it both ways.
And that was what the union was claiming, that there was a difference and that they felt that one of the ways to fix that is at least at the very minimum to have licensed physicians in California making that decision. And so that they would be held to the same kind of standards that you're held to in terms of your standard of care. Everybody be on the same page on the standards part. But they lost, and that was a political loss, not necessarily a substantive kind of on the merits loss.
And on the enforcement side, we do get complaints involving those types of allegations that patient care was denied because of an expert reviewer. On those cases, we collect records, we get a response, but for the most part, we also refer to the workers' compensation. There's a review board within that department that will review those types of situations as well.
Where we would get, and I don't think this board does, but other boards that are not physician boards get fraud cases related to workers' comp, where they're, physicians under workers' comp will be in a fraudulent scheme to deny or approve, workers' comp claims. So it's not without its abuse, and that's why it kind of keeps getting scrutinized, but not all the problems have been solved for sure. Any other questions on bills?
No? Are there any comments from members of the public in the audience? Any comments, moderator, by public online?
This is the moderator. We are open for public comment on WebEx. If you would like to make a comment on this item, please raise your hand or use the Q&A feature down at the bottom right-hand corner of your WebEx screen. All right, it appears there are no requests for public comment.
Thank you. Let's move to agenda item number 15, update on rulemaking. We'll continue on with Terry.
Okay, thank you, Madam President. Well, not on the menu, but I think I'm going to tee it off right away. The good news on that CME cite and fine package. I tried to give you an idea how long, when we say, oh, it's a long, tedious process. The memo here is trying to give people an idea, like all the different steps. But our CME package, cite and fine, got approved to go out for public comment. And I'm going to be submitting that in the next day or two. And it's got to go out for 45-day comment, after which we put together the packet. It goes to the Office of Administrative Law, and they have 60 days to approve it or deny it. And then depending on if it's approved, then they have this like calendar system of if it was, I think April 1st, for example, is if you get it approved by OAL, you could have an implementation date of April 1st. If we miss that, then we'd have to go to the next one that may be in July and so on. So that was good news because we had no idea how fast it would go through the process. And given that this was something that has taken a really long time, we started in 2018. This board is probably voted on it maybe 8 times, as many of 8 times. I think that the speed in which it was approved shows the quality. So it was well worth the wait and well worth the repeat consideration that this board took to accept the changes and to slow it down to do it. It was, you know, for me, it would cause a lot of heartache to have to pull it back, but each time I knew that it was better. And I think that the speed in which demonstrates the quality of it. And that has a lot of goodies in it, not just CME, but it is, Dr. Patel, what is holding us back from the audit and the self-renewal. We can't implement that until the reg package is implemented. So that's what we're waiting for. I can't make any guarantees, but I mean, if things keep going fast, we could be getting approval maybe April 1st, maybe July. And then we work with, and you know, the mismatch is that we can do some preparation, but we can't begin to work with Breeze to implement stuff until after its effective date. So it's coming. It's not in 2 years from now, which is what it felt like to me. It could be this year, in the next year in 2025. So that is definitely on all of our radar screens to implement that as fast as possible once it gets implemented.
Just to give you an idea, Dr. Patel, how fast we're going with this, Terry and I got the email at 11 a.m. 2 days ago, and we've talked to 3 separate boards already. We got templates from them on how they do their audit. So we're excited about this. We were thinking it was going to be 60 days before we heard anything. And the moment we got the email, I asked Terry, are you reading this correctly? Am I reading this correctly? We got to jump on this. So that's how fast we're moving with this in preparation for all of this.
No, thanks for all your hard work. I remember Mark Ito talking about this when I wasn't even a board member at an OPSC meeting a long time ago, and it's a long time coming. So hopefully everything goes well, and it'll just create better efficiencies for not only our staff but for our licensees too.
Yeah, well, as I wanted to point out, I'm maybe jumping around, but the steps in we combined, and I think I am jumping around, but I talked about in terms of workload, that we combined separate subjects that could have been their own regs into one. And in doing that, like we were on the verge, I think over a year ago, to just do the CME, which would have accelerated that. But there were legal concerns that our regulatory counsel says, you know, you're going to be changing the same law and you're going to come behind with a second package that you approved in August, which then could cause some mix-up in terms of which law goes into effect at what time. So they said, let's get rid of that problem and just put them together so they get implemented on the same date. All the laws, agree with each other, so we don't have that problem. So that complexity alone, combining cite and fine with CME and audits, really slowed it down. But in the end, and then that last, as you remember, we didn't go over the whole bill. We just went over all the laws that we needed to update. And so now it's going to look clean, which is a way to for sure get it approved. And it's going to be pretty vast in terms of implementation for totally revamps our renewals, our CMEs, our introduces self-renewals, as well as audits, which we need regulatory powered audit. And then the cite and fines, the best thing, I don't want to jinx this, but it's just like a dream, the kind of language that we put in there that the medical board got approved, which is the way that it is now, we have to, every time there's a bill and it creates a new violation, which every year we have bills that we have to, create new violations and enforcement codes in Breeze, we technically have to, if we want to have cite and fine authority, we got to put it in a reg package. So prior to this latest version of the reg package, we had 30 to 50 different statutory sections, some no longer good, some that were new, that we were adding to the reg package. And so to be able to request authority, which basically says if the board has jurisdiction over the issue, the board has jurisdiction to issue a cite and fine. And that's, you don't get better than that for streamlining in terms of enforcement and cite and fine. So that will be huge in terms of that one coming down the line. So I want to back up because I wanted to give new board members, and I don't think I've done this with even existing board members, an idea of what's involved in regs. I always introduce reg packages as an incredible opportunity to lean in. This is where you get to make your, laws and rules, so to speak. But it takes a long time and it's very tedious. So I put in bullet points sort of what are the stages. So, one of the stages is obviously concept and drafting. So at that stage, we're looking at what problems, gaps, need for updates, new authority that we need to address and implement statutes that are too vague, that we have to put take them out of the vague part and make them specific in terms of requirements. That's the first section. And then because DCA has a reg unit, we work with the reg unit and DCA's budget staff because they eventually have to approve both the text and the reg package, both budget-wise, in terms of the numbers and the language. That pre-review really helps kind of speed up the process because the longer it took those two kind of units in DCA to look at regs, if we did it wrong and they're like, whoa, no, that's a bad approach, then we had to start over again. It just took longer. So getting to meet with them with our concept up front, I think has turned out to save a lot of time. And then we propose the language once legal and budgets has said, yeah, I think you're going in the right direction. Then we bring the language of what we want to put in the actual regulation to the board for your review. And that's where you're putting the rules in. If you recall on one of them, not the CME, but you were concerned about like, what are we asking for in terms of a phone number or contact and stuff? That's your opportunity to say, I think we should require this, or we shouldn't, or modify it. So that part is your role, and whatever you modify or approve, then that's what we then use to create the actual, what they call regulatory packet. And the regulatory packet is much bigger than just the language. There's several required documents that we have to complete. One is a fiscal document. One is what they call a notice that kind of summarizes to the public and the world what are the things we're changing, both in statutes, adding, repealing, modifying, exactly. What are we doing that in a summary form? Then we have a longer document called the initial statement of reasons, or short ISOR. That is where we have to justify. I know, I love that. That's where we have to justify to everybody that has to review this, why we're doing this, and do we have the authority, and is it a good policy? Does it make sense? Are we, asking too much? Are we going beyond what we should be doing? So we have to justify why in that document for every single change. That's what makes it get really pretty long. Erica made some reference to maybe the disciplinary guidelines that you'll review could be 100 pages. When I did it, it was 186. So it's a long document because you end up having to say, well, we're adding osteopathic to every term that says physician and surgeon. That was one change. We have to, justify that each time. Then after we have that proposed language, we have the package all together with minutes, statutes, supporting documents. Then it has to go to the DCA director for approval. She reviews it, and he or she, so she now, approves it. And after her approval, it goes to agency, and they review it and approve it or not. And then it also goes to the Department of Finance, and they review it and approve it or not. Now, just as I don't want to jinx our reg package, but in the past, we've gotten tons of questions at the director's level, at agency, and the Department of Finance level on all of our reg packages, and we didn't this time. That's why Eric and I were so surprised. So that's what you call a really well-written reg package. So I'm pretty proud.
Can you explain agency to me?
Agency is the housing and consumer housing and, what is it? It is a long name. Isn't it up here? Yeah, it is. Consumer Services and Housing Agency. And it has a DCA as a department. It has affordable housing department under there. It also has gambling, no, the racetrack under there. A lot of things that would be related to business there that's not in our department, and DCA under that umbrella. That's what we refer to as agency. And all of the departments have an agency above them in terms of between them and the governor's office in terms of hierarchy. So the agency review is beyond, and their jurisdiction is beyond just one department. So when our director approves it, that director is approving it within that, our agency's jurisdiction. But agency then, because they represent multiple departments, they then look at it, is there anything wrong with this, from both the DCA or any other reason politically? And then Department of Finance looks at the numbers. Are we good? Are the numbers that we're proposing as fiscal and economic impacts accurate and make sense? That's what they look at. And then that's, so it never goes to the governor, but the Department of Finance is kind of the sign off for the proxy for the governor's office. So those are something that, those are the levels before. The ultimate agency is the Office of Administrative Law. Their main function is to approve and review all administrative regulations. So I would normally think, oh, that's the one approval, but that's not. We have department, agency, Department of Finance, and then the Office of Administrative Law. So one of the things that I guess goes in our favor, and the significance of the announcement we got, is that they when you introduce some regs to the Office of Administrative Law, you have 1 year. The clock starts ticking. If you don't have that approved or denied by then it gets kicked out. You got to start from scratch. So one of the ways they've developed how to not use up that time clock is all the what they call pre-reviews, the department, agency, and DOF. That happens before we file it, before that time clock starts kicking. So now, since we've gotten those pre-reviews, now we have, starting from November 22nd, 1 year to get that approved. And the things that we need to, the real agency that we have to deal with is going to be the Office of Administrative Law. They have 60 days. There could be a back and forth that occurs that could take longer, but we're in pretty good shape, to have a full year ahead of us with only 60 days taken up by that particular department to review and make the final decision. And then after that, also we have to publish it. So there's specific procedures that the Office of Administrative Law publishes it to the Secretary of State, just like the legislature sends to the Secretary of State the new legislation to be published. We have to do that. And then that quarterly calendar that's required is anything that happens between, a particular date like September 1st to October 30th, has a date that that's the publication date. And if you miss that, then you got to wait for the next publication date. And there's 4 of them. And that was imposed because there was a complaint that regulations, it was hard to keep up on regulations that could get implemented or effective like immediately on any given day. So they figured it'd be easier to, businesses that is, would be easier to keep track of regulations that only come into effect 4 times a year. So that's why we have to fit that calendar. And so then the effective date of regulations is when it's published. So even though it might be approved at a different date, the effective date is that one of those 4 dates within the year to publish it. And that's what like Bree's team needs, that effective date. Everybody needs that effective date for when we're starting. So that is the process for regs and a reg package. And then I just wanted to give you kind of give some institutional knowledge to our reg packages. We have three main ones that are priorities. The site fine and the CME is the one that is moving fast. And that was combined, as I mentioned. What I would call the fees and licensure package that you approved in August, that one is being made into a package, the eyesore and the notice, all those documents, the budget documents, those are all being created by staff, and we're working with DCA and our regulatory council for that one. And that one is a combined package. So from a workload perspective, we have more than 3 active. When we say we have 3 priority packages, we really have like 8 or 9 because they've been combined. And why I'm pointing out that workload is because I was in charge of doing, and Erica, regulations, and the volume of regulations that are backlogged that we need very desperately, we couldn't do in addition to our regular job. So Erica hired Becky to help us, and her assistance is what's making the difference of really starting to produce reg packages within a year or two, because we don't have a dedicated person, and we've asked. And so I just always want to point out to the board needs a dedicated reg person, and we keep asking. And so to the extent that you also feel strongly about that, because we're in backlog, disciplinary guidelines still waiting, it's something that could be something the board supports. And I think it's in our strategic plan, so that's good. But I wanted to put which ones we have on the burner and why they're priorities, and kind of break them down into types. So the disciplinary guideline could be considered one, but it does have 2 aspects. One of them is the uniform standards for substance abusing licensees, a statute that was put in place, I think, let's see, could have been like 2013 or something. And we've been in compliance through our Maximus contract, but because we don't have regs to implement that, and those standards created standards for testing for people on probation for substance abuse, how often they have to test and what that regimen is, what kind of vendors you use. So those standards are always in our contract with whoever we, contract with for diversion, but we need to have those incorporated into our disciplinary guidelines. And the last 2 times when I drafted them, the disciplinary guidelines was a point of contention. And so we need to resolve that, the position that the Office of Administrative Law wants us to incorporate those standards into the disciplinary guidelines, how to do that. So that's yet to come. Any questions?
With regard to regs, is the challenge finding that person or finding funding for that person?
Well, every position needs to have funding, and it needs to have approved funding, and it has to be approved by both the director and the legislature. So it's a process that is not a single process. Unfortunately, Eric can't say, this is who I want, and I need the money to pay for it. She's got to go through a process, first through the department, then eventually through agency and OFF and the legislature to get positions and funding approved. And if that's approved, it then draws down on our fund, that I think was referenced in the budget overview.
We've kind of undergone this process, Dr. Lockman. It's called a budget change proposal. And last year, actually July 1st of this year, we were granted 2. One of them was an augmentation to our attorney general fees because we were over expending in that line item tremendously. Currently, in enforcement, that's our biggest I would say our expenditure comes from that, area. So we have that issue that was taken care of July 1st. And then through the mandate of SB 815, because of added workload, we had to submit the budget change proposal for two of those AGPAs. So for anything extra that the board needs, that's the process that it would follow. Every year we're given a chance to submit a concept paper, which we have to submit enough proof that the workload is there. and the need is there, and that we are able to afford getting those positions, because that comes out of our current, funds, which goes along with our fund condition. So if you recall, when we looked at our budget in 2026, 2027, that funding is being depleted, and that is projected with the current changes that we have right now. So in order to ask for more positions, we need to bring in more revenue so that that could get approved. And that's what we're working on. The second packet here that Terry had mentioned includes the fees, which is a generalized, there's a couple of fees there that we're working on. Like I mentioned earlier, the application fees, creating petition fees, and then also we're introducing a new license status, which will bring in some revenue, which is the retired license status as well. So we need to work on bringing in more revenue so that we can have enough funds to submit budget change proposals.
The other delay I would point out is that when the budget is in deficit mode, as it is in this year and next, pretty much, and nobody has a chance of getting any extra positions or money. The focus is all staying within our budget, cuts to programs, and unfortunately that can happen a lot. So like this is 2 years where we're kind of knocked out of the box. We still put the request forward, but probably it won't be successful. So it puts a lot of time for, in between. Like you identify a need, it becomes a priority. We put it in the strategic plan, and yet we're still waiting and waiting and waiting for permission to add the position and to add the funding. And so we're doing all this, all the other stuff that we were told we have to do in the reg packages, capping off our fees, creating the new fees from the legislation. Those will help. And we have to do that as a precursor to be able to be approved to get any new positions. Another thing I would point out in terms of new positions is each year, bills may require new staff to implement. And so the new staff from bills usually overrides what the director's, Erica's desire for new staff is. So she has her own list of like, what workload do I want to get new staff for? But then you get a bill that says, oh no, now you got to add 2 people in order to, do this new function. And so we keep adding. So yes, we add staff, but we add staff to implement priorities that are new through legislation, not only the board's priorities of what their existing day-to-day operation and workload is. So that's also kind of a frustration, but we're still asking, but it's not up to us, unfortunately, which is counterintuitive. You think special fund, we should be able to get what we want, but that's not the way it ended up working. And the last page just shows you where we are on the 3 packages I talked about, all the different steps. And then I put dates to give you an idea of how many meetings or decision points we had. So like on the pre-review on the top for the continuing education, just the pre-review, we had 1, 2, 3, 4, 5, 6 different meetings and dates just for that particular process. Same thing with the board approval. Those are all the dates the board approved the language. Then drafting, the regulatory documents, we had to redraft some after we made more changes. So there were 2 dates. And right now, because it happened yesterday, I didn't get to say approved under agency and under DOF, and we should be able to say a filing regulatory package with OAL. We already did that. It already got done for us. So those are to update that one. The rest are accurate in terms of the fee and license. We did the concept, we did the pre-review, board approved the language in August at their last meeting, and right now we're in the draft of the regulatory package at this point. And disciplinary guidelines, you can see the concept, and then we're also have had a lot of pre-review, continuing on that pre-review. More to come before we produce language that goes before the board. So those are where the packages are. that we're working on.
Thank you. Are there any other comments from members of the board? Thank you. Any comments from members in the audience? Any comments from public members online?
This is the moderator. I've opened up a public comment on WebEx. If you would like to make a comment on this item, you can click the raise hand icon, or you can click the Q&A icon down at the bottom right-hand corner of your WebEx screen. All right, and it appears there are no requests for public comment at this time.
I don't know. Okay, thanks. Okay, we are now, thank you, Carrie, I appreciate it. That was a lot.
You're welcome. It is
Really
always a
informative,
lot.
though. Very informative.
Good, good.
Thank you for walking us through the process. I don't think we really actually knew what was
We didn't. That's what
all
I thought.
involved. And
Well,
it's a
and
lot.
I want you to
Oh my
understand.
God. I mean, to see something like start in 2018.
Yeah,
and
I
we're
know.
still like, are we serious? I
Yeah,
have a kid in college.
I know. And yeah, that one's a long, it felt like the forever reg package that never ended. I just like couldn't believe it, but it did get better. Our reg attorney is so incredible.
Okay.
And all of the changes that she wanted us to make were really good changes. You know, like when you think about somebody that's state of the art, she's state of the art in terms of what her assessment and her wording and her recommendations for regs. So, you know, we haven't had that kind of quality before. And so it feels pretty good to have it.
The question was asked if you can say her name. Christy?
Oh, Christy Scheld. I always say it wrong. Scheld. There's a lot of consonants.
Okay.
And yeah.
Thank her.
Yes.
For us, please.
Yes.
Okay, we are now going to move to agenda item 16, the establishment of an executive legislative, some committees we're going to do. An executive committee, legislative licensing committees, enforcement committee, education and outreach committees, and I will present the committee and the member as a way to support the board on key issues and initiatives where we feel like we have a little bit more of a chance to have some involvement into the process of some advanced thinking that we can present during board meetings. So the executive committee is myself and Andrew Marino. The legislative committee is myself and Dr. Patel. The licensing committee, Dr. Swain and Gore. And the enforcement committee, Dr. Lockman and Mr. Cummins. And the education and outreach, Dr. Patel and Dr. Swain. So I want to see if there's any discussion by the board members. Okay, great. This is the first time since I've been on a board that we have committees. I think it's because we have a full board and I think this is a very engaged board. So I'm looking forward to what the committees work on and come up with. Are there any comments from members in the audience that are present? Any comments from members of the audience who are online?
All right, this is the moderator. We're open for public comment on WebEx. If you would like to make a comment, you can raise your hand or use the Q&A icon down at the bottom right-hand corner of your WebEx screen. All right, and it looks like we do have a request from Holly Marcris. And Holly, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Tell you I'm super excited for all the things that I've heard you being discussed today. OPSC wants to be able to help you through any of these things that you're talking about. And
Who's ever here right now? We can't hear.
Oh.
Holly, could you try speaking again? It seems like the room was not able to hear you.
Okay. Can you hear me now?
Yes.
Yeah.
Okay.
No. What happened?
Holly, if you're currently speaking, it doesn't appear that we can hear you right now. And perhaps she's not able to hear us either. Holly, are you able to hear us?
I can hear you now.
Okay, I can hear you now too. So if you want to go ahead and start over. Is the room able to hear her, correct?
Yes.
Okay, perfect.
Okay. I'm so sorry. I don't know I'm at UC Davis Med Center right now, so I apologize. Maybe that's something that's happening here, but I'll try it one more time. Thank you so much for everything that you've been talking about today. It's been very informative. I took lots of notes, and I'm super excited for everything that OMBC is doing. Please know OPSC is here to assist in however way that we can provide information or assistance. And then also the reg package we're working on very hard right now for you all. So we should have some language for Erica to be reviewing any day now. I know she got a first draft, but we're still working on that language. So just super excited for everything that you're doing and glad to be part of it.
Thank you.
All right, and that appeared to be our only request for public comment.
Okay, thank you so much. We are going to move to agenda number 16, future agenda items. But before we conclude, I would like to ask the board to consider a new board date in January. So instead of January, I think we're 21st, January 30th. It's a Thursday, so it's a 1 week later. We would need to vote on this new date. And so I wanted to see if we all needed to check our schedules before we agree on this new date change. So it's January 30th, Thursday, 2025. Works for everyone? Okay.
It may or may not for me, but I'll try my best because I have to put up my schedule a little bit in advance.
Okay.
But I'll let, if it goes through, we'll figure it out.
Okay. Is there anyone else?
I'll have to review my work calendar.
Okay.
I will do it. I think it's good.
Okay, great. Mr. Cummins? Okay. Okay, great.
Ms. Pines, we could send out a survey, a doodle poll to see if everybody's available, and then I'll let you know. Does that
Okay.
work?
Would you like to do that? Do we need to do a vote to change this date?
Well, we don't have to vote on it now.
Okay.
I can just send out a survey and see if of everybody's availability, and if we have quorum, we can just change it.
Okay.
Yeah.
Is that the direction everyone would like to move in? Okay, great. Okay, perfect. Okay.
Since we're on the topic, can we see if we can finish the August 14th as well? If possible.
Oh, yeah.
Yeah.
No worries.
We don't seem to have quorum issues with this board, so I think we're okay. But we'll double check everybody's availability just to make sure.
Okay, great. So we'll do a doodle date and see if that works for everyone in terms of the new January proposed date. We also have been, how long have I been asking for this presentation on the aging brain? I think 2 years.
2 years, yeah.
What the heck, it cannot be this difficult. Is this person ready for January?
We're hoping that in January, we will be ready to go. Yes.
And then we are looking at a possible presentation from CDPH director. Is that correct? Or the CDPH?
That is correct. Yes, I'm in contact with the Department of Public Health right now to set up something in terms of a request was made for the exchange of information when it comes to patient harm and notifying the board in an expeditious manner and how that gets handled. So I'm reaching out to people at CDPH to get a presentation set up for us.
Okay, great. Are there any board members that want to have a future agenda item added?
Yeah, I would suggest maybe inviting Dr. Gimple to talk about I forgot what it's called, that pilot, Machiko knows. Yeah, maybe when we have a meeting at one of our schools, that might be good, just to not pack up the agenda for next time, but in the future. Yeah.
Okay. Is there any other board member that is interested in a future agenda item? Yes.
Well, just that I know that we're going to be starting the new diversion program. So perhaps if there could be an update on that because it's coming to an end in December.
Mhm.
So in January, I think it'd be appropriate just to see how that transition is.
Okay.
Perfect.
Do we want to have a presentation by the new organization?
Actually, that's a great question. Andrew, do you want a presentation from them and their services, just like we had Maximus do a year ago?
I think that would be helpful.
Okay,
Yeah.
perfect.
Any other future agenda items by the board? Seeing none. Any comments by members of the public in person? Any comments by the public online?
All right, this is the moderator. We're open for public comment on WebEx. If you would like to make a comment, you can raise your hand or click the Q&A icon at the bottom right-hand corner of your WebEx screen. And it looks like we do have a request from Michelle Montserrat Ramos. And Michelle, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device. All right, and you are unmuted.
I am Michelle Montserrat Ramos, and I'm a consumer watchdog. We agree with the board member who just made a request for an agenda item on the transition of the diversion program. We're also requesting an agenda item to include a presentation on the transition of the diversion program from one vendor to the new vendor and the impact on the probation department, including which type of participants are monitored in-house by the program manager. Thank you.
Thank you. Is that it?
I've got something
Yeah, I just wanted to make sure we were. Moderator, is that it? Was that the only comment?
Yes, it appears that was our only request for public comment.
Okay, great. Thank you. Yes. I thought Dr. Lockman wanted to say, okay. Dr. Swain.
So was wondering if we've ever talked about or considered we should, if we haven't, I would like to propose a future meeting agenda item on having a student or resident board member as a way to kind of bring that whole segment of our future population. Like we have that, I've seen that in a lot of other organizations, where they'll have a student member of the board. And they may not be able to be fully voting members or whatnot, but it brings them in and talk with their friends. And anyway, I think that we should talk about that in the future as to what that would, if that's what we want to do and what it would look like.
Okay. You added that?
I'll look into that with legal counsel and look at the idea a little more closely. I don't know if that would require ledge change, because our legislator, our statutory this specifically spells out how this board is made up of. So it might require a change at that level, Dr. Swain. So we would have to look into that.
Our final agenda item is agenda item 18, which is we're moving into a closed session. And then this is adjournment for the session that we've had today. Thank you. So I think there are folks that have to stay and leave.